The court said, "You may call your next witness."
Mr. Skirrick said, "Your Honor, the defense calls George Higginbotham."
George Higginbotham, called as a witness by the defendant, having been duly sworn, testified as follows.
The court said, "If you please state your name and spell it. You can be seated and bring the mic close to you so we can hear you."
The witness said, "My name is George, George, Higginbotham, Higginbotham."
The court said, "You may inquire."
Mr. Skirrick said, "Thank you, Your Honor."
Direct examination by Mr. Skirrick.
Good afternoon, Mr. Higginbotham.
Good afternoon.
Were you once employed by the U.S. Department of Justice?
The court said, "It's a yes or no question."
Yes, I was.
And when was that?
I was employed from August of 2016 through August of 2018.
And why was your employment ended in August of 2018?
I was terminated because of my involvement in a conspiracy having to do with an influence scheme with a number of other co-defendants.
And have you ever spoken with any of the lawyers withdrawn? Aside from discussing travel arrangements, have you ever spoken with any of the lawyers on Mr. Gua's defense team prior to your testimony?
No, all communications were through my own counsel.
And have you, again same question, aside from discussing travel arrangements, have you met with any of Mr. Gua's lawyers to prepare for your testimony here today?
No, I haven't. All communications were through my counsel.
Now, have you ever met Miles Gua before?
No, I have not.
And have you ever spoken with him before?
No, I have not.
And, sir, why are you here today?
I was subpoenaed to testify by the defense.
Now, Mr. Higginbotham, have you ever pleaded guilty to a crime?
Yes, I have.
And what crime did you plead guilty to?
Conspiracy to make a false statement or false statements to a bank, 1 count.
And when did you plead guilty to that conspiracy count?
November of 2018.
Were you working as a lawyer for the DOJ at the time of your conduct that resulted in the guilty plea?
Yes, I was.
And, sir, with whom did you conspire?
Pres Michel as well as Elliot Brody and I believe Nicky Lum Davis were the co-conspirators as well as Joe Lowe.
And who is Elliot Brody?
Elliot Brody was an influential figure in the Republican Party.
And who was Mr. Pras Michel?
Pras Michel was my client at the time. He was an entertainer, rapper, and musician. And I met him through my work in the music industry.
And I believe you referred to someone as Joe Lowe, is that correct?
Yes, Joe Lowe.
Is the spelling J-H-O, last name, L-O-W, for the court reporter?
Yes.
And who is Joe Lowe?
Joe Lowe is a financier who has been implicated in the 1MDB embezzlement scheme that took place earlier a number of years ago.
And what is your understanding of what the 1MDB scheme was?
My understanding is that there was a sovereign wealth fund established in Malaysia established by Joe Lowe in association with other government officials. Sovereign wealth fund is basically where the government of a country backs a particular financial instrument. It's my understanding that or allegedly Joe Lowe was the mastermind behind embezzling billions of dollars from that sovereign wealth fund that is named 1MDB.
At the time of the conspiracy, to your knowledge, was Mr. Lowe the subject of an asset forfeiture claim that was brought by the Department of Justice?
Yes, he was.
And those asset forfeiture claims related to Mr. Lowe's role in the 1MDB scandal?
Yes, it was.
Did you ever meet Joe Lowe?
I did meet Mr. Joe Lowe in Macau somewhere around the timeframe of September of 2017.
We'll come back to that in a second. When did you join the conspiracy to which you've pleaded guilty? Approximately month and year.
I was first approached about Mr. Michel assisting Joe Lowe, I would say the first 2 or 3 months of 2017.
And how did you become involved in the conspiracy during that first few months of 2017?
My relationship with Mr. Michel went back a number of years, probably to early 2002, 2003. And I had represented him on a number of matters. He approached me and asked me whether or not I knew someone that might be able to assist in a matter that was in front of DOJ. And then I came to find out that it was the Joe Lowe forfeiture matter.
And what did Mr. Michel discuss with you about the Joe Low matter?
He said that there was this forfeiture matter which is a civil matter in front of DOJ and that Joe Low was in need of an attorney that had not only legal gravitas, but also I would say influence within the government, because he felt that part of the resolution of the matter would be somewhat political. And someone with political connection might be able to assist in resolving the 1MDB matter.
And what did you do to help with this issue?
My primary responsibility was to draft contracts.
Well, maybe, let me try it this way. What did you do first to help with this issue?
Mr. Michel approached me and asked me if I knew any influential lawyers that could potentially assist Joe Low. As it turned out, there was a neighbor in the building that I was living at the time in Washington, D.C. that operated a very high-level powerful headhunting firm for lawyers. I approached her. She suggested 2 firms. I believe one of the firms was conflicted out, and the other firm looked to be of some promise to Mr. Michel.
And ultimately was someone brought in to help Joe Low with the 1MDB asset forfeiture issue?
Not from either of the 2 attorneys that were suggested through my neighbor.
Was someone else, not an attorney, ultimately brought?
Yes.
Who is that?
Mr. Michel was able to gain an introduction to Elliot Brody through Nikki Lum Davis. And Elliot Brody was willing to assist in this matter.
And Elliot Brody, you testified before, was someone of reputed influence in Republican politics.
I believe he was a large Republican bundler in terms of election funds.
And what administration did Mr. Brody purportedly have influence with?
The Republicans.
And what year is this again? This is 2017.
This is 2017.
Now, aside from the 1MDB aspect of the conspiracy, was there a second goal of the conspiracy as well?
Towards the beginning of the summer of 2017, Mr. Michel told me that there was an opportunity that could potentially be lucrative to us in terms of working through the same people. And that was the extradition of Guo Wengui.
Could you just bring the microphone a little closer to your face?
Sure.
You have a deep voice. Sometimes it trails off. Could you repeat that last answer? I'm sorry.
Yes. He told me about an opportunity that he had been discussing, which was the extradition of Guo Wengui.
And is Guo Wengui, Mr. Guo, sitting here at the defense table?
I believe so. I was introduced to him through Praz or through Mr. Michel as Guo Wengui.
By name?
By name, yes.
Now, where were you when you Mr. Michel first made this request?
I was here in New York City.
Were you at Mr. Michel's apartment at the time?
Yes, I was.
And when was this approximately?
I would say.
Month and year again if you can.
Yeah. I would say late June. I would say June timeframe of 2017.
Now, what did you understand the Chinese government was willing to give in return for the successful extradition of Mr. Guo?
Well, Mr. Michel presented a very fantastic story to me at the apartment at the time that he brought up this particular matter.
Ms. Murray said, "Objection, Your Honor, hearsay."
The court said, "Don't say what he said."
The question is your understanding.
My understanding.
Yes.
My understanding is that the Chinese government would potentially, if my memory serves correctly, offer a prisoner exchange. There was purchase of high-ticket items like planes from U.S. industry, improved relations. There was a number of things, but I think those stand out in my mind.
I believe you said before that your understanding was that to you and Mr. Michel and the others it could be potentially very lucrative.
Yes.
Now, what was Mr. Brody's role in securing Mr. Guo's extradition to China?
Mr. Brody, given his position in the Republican Party, had a number of contacts that he was purportedly or allegedly going to use in order to help resolve the 1MDB matter as well as the extradition.
The court said, "What do you mean by resolve?"
The witness said, "Well, it's my understanding that the 1MDB matter was a forfeiture matter, and so it was Joe Low who wanted that matter to be resolved."
The court said, "What do you mean by resolved?"
The witness said, he wanted to gain access back to the U.S., and he wanted to come to some kind of agreement with the Department of Justice so he could continue his actions and dealings with the U.S.
The court said, "Go ahead."
Mr. Skirik said, Thank you, Your Honor. Now, did there come a time that agreed to meet with the ambassador withdrawn? Did there come a time when you agreed to meet with the U.S. ambassador from China?
Yes, there was.
And this was in connection with the conspiracy, correct?
Yes, it is.
And when approximately was that?
That would have been late June, early July of 2017.
And why were you meeting with the U.S. ambassador from China?
It's the Chinese ambassador to the U.S.
Thank you for that correction. The Chinese ambassador to the U.S. Why were you meeting with the Chinese ambassador to the U.S.?
Mr. Michel asked me to communicate a message to the ambassador.
Did you in fact go to the Chinese embassy in Washington and meet with China's ambassador to the U.S.?
Yes, I did.
And when was that?
Ms. Murray said, asked and answered, Your Honor.
Mr. Skirek said, the first question was with respect to when the request came.
The court said you may answer.
I met with the ambassador on a Sunday. I believe the request came in on a Friday for Mr. Michel. He told me he would give me more instruction. He was on his way to D.C. And I met with him earlier on the Sunday before I met with the ambassador.
Now, aside from Mr. Michel, did you speak with anyone else withdrawn? Did you speak with anyone at the Chinese embassy prior to your visit with the ambassador?
I believe I spoke with one of the ambassador's assistants to just coordinate the meeting.
And what did the ambassador's assistant instruct you to do?
We agreed on a time for the meeting on that particular Sunday and come to the embassy.
And what did he instruct you to do when you got to the embassy?
I'm not sure I understand the question.
The embassy is presumably a large building.
Yes.
What was his instruction to you as to how to gain access to the embassy?
I went to the front door, so to speak.
Mr. Skirek said, if we could please pull up just for the witness and parties DX 60763. Mr. Higginbotham, when you went to the embassy, did you meet a couple of individuals from the embassy staff before being introduced to the ambassador himself?
Yes, I did.
Did those individuals present you with business cards?
Yes, as I was leaving.
Can you see the screen in front of you?
I can.
Do you recognize those business cards?
I believe these are the business cards that I turned over to DOJ when I was approached about the matter.
Are these the business cards that were given to you by the Chinese embassy staff?
Yes.
In July 2017?
Yes, I believe so.
Mr. Skirek said, Your Honor, we move Defense Exhibit 60763 into evidence.
Ms. Murray said, no objection.
The court said, it is admitted.
Defendant's Exhibit 60763, received in evidence. By Mr. Skirek.
Now, Mr. Higginbotham. Could you please tell the jury what happened at your meeting with the Chinese ambassador?
It was a relatively quick meeting. I was brought in by the assistant to the ambassador. I was ushered into a very, very large conference. I believe that they had tea available there for me. The ambassador came in a short time later. We exchanged pleasantries. And he said in effect, okay. What is the message? And the message was that there were successful efforts being made for the extradition of Mr. Guo Wengui and that there would be additional information forthcoming from General MIC Master.
And who is General Mike Master?
I do not remember what his exact position in the administration was at the time. But I believe he was involved in the national security aspect of the Trump administration.
So a senior official in the Trump administration?
Yes.
Now, what was the Chinese ambassador's reaction to the message you delivered?
I remember him being quite stoic. There wasn't any particular emotion. He asked additional questions. Unfortunately, I did not have any additional answers. And the meeting ended almost as quickly as it began.
Now, after the meeting with the Chinese ambassador, did Joe Lo send money into the United States to you?
Yes, but that wasn't until I believe the October time frame. There was a significant amount of money that was sent to my firm IOLTA account.
Maybe we can just back up a half step to talk about the money. How were you and the others compensated for the work that was taking part as part of the conspiracy?
Well, Joe Lo was funneling tens of millions of dollars into the U.S. into accounts that were maintained by Mr. Michel. And I was paid by Mr. Michel for my services.
And after the July 2017 meeting with the ambassador, do you recall whether there was a payment that came from Joe Low in August of 2017?
Please understand that at this particular time there was a significant amount of money that was coming in from a number of Joe Low's shell companies. So, yes, money was still flowing in. But at that time Mr. Michel had a business manager and it was responsible for that money. And I wasn't directly involved in overseeing that money coming in. Or in any way, there was just a tremendous amount of money coming in at that time.
And when you say a tremendous amount of money, just for the benefit of the jury in terms of quantifying that, tens of millions of dollars.
Yes, I think that the final count was somewhere plus or minus 100 million.
Now, did there come a time when you took any trips abroad as part of the conspiracy?
Yes. I traveled to Hong Kong and then immediately to Macau in September of 2017.
And this was approximately 2 months after your July 2017 meeting with the Chinese ambassador.
That is correct.
And why were you going to Hong Kong?
It wasn't immediately revealed to me why I was going to Hong Kong. But when I met Mr. Michel in Los Angeles, he told me that I was going to be playing the role of an advocate up for Elliot Brody. And that because a significant amount of money had come in up until that point. And neither the 1MDB matter was resolved nor the extradition had taken place. It was a meeting to assuage Joe Low into believing that actions were still being taken to resolve the 1MDB matter as well as the extradition of Guo Wengui.
And I should have asked this before. Do you have an understanding as to why the Chinese government wanted Mr. Guo extradited to China?
Ms. Murray said, "Objection, Your Honor."
The court said, "Sustained."
Mr. Skirek said, his understanding.
The court said, "What do you understand the word extradition to mean?"
The witness said, "I understand the word extradition to mean that the United States government would formally extradite or formally remove an individual and return them to the state that is, or the country that is requesting them to be returned."
The court said, "Go ahead."
Mr. Skirek said, "Thank you, Your Honor." How did you get to Hong Kong?
We flew from Los Angeles.
Please tell the jury what happened when you landed in Hong Kong.
We landed in Hong Kong. I exited the plane off the jetway. Mr. Michel and a couple of other people that were with us when I got to the top of the jetway were on a golf cart. He asked me to jump on the golf cart. I jumped on the golf cart with him. And we were pretty readily whisked through the airport.
Were you required to go through immigration?
Not that I recall, no.
Were you required to go through customs?
No, not that I recall.
Were your passports stamped?
I do not believe so, no.
Were your passports taken from you?
I believe so.
Now, how did you get from Hong Kong to Macau?
By ferry.
And were you originally supposed to travel by a ferry if you recall?
We were originally supposed to travel by helicopter. But the weather did not permit helicopter flights on that day.
Now, what is Macau?
I believe Macau is a protectorate of the Chinese nation. I do not know its exact distinction.
But it's part of China.
Yes, I believe so.
Or at least governed by China.
I believe so, yes.
What happened when you got to Macau?
I was given keys to a quite nice hotel suite and instructed to wait for further instructions really.
And were you given anything to use to communicate while you were in Macau? Any device with which to communicate when you were in Macau?
I believe I was given a cell phone, but I do not recall immediately.
Was the hotel reservation at this hotel in your name?
No, it was not.
Now, did you meet with Joe Low in Macau?
Yes, I did.
And where did you meet him?
The first time I met him was for dinner at a restaurant in a hotel. And the second time that I met him was I believe the next day in one of the hotel suites.
And at the dinner the first time you met with him, what, if anything, was discussed about the progress being made on the extradition of Mr. Guo?
I don't believe that topic came up specifically.
What topics did come up?
Ms. Murray said, "Objection, Your Honor, hearsay."
Mr. Skirek said, "I'm asking about the discussion."
The court said, "The general subject matter, you can testify as to that."
The general subject matter resolved more specifically around the movement of money and the difficulties moving such large sums of money in such rapid fashion were presenting.
And do you recall, was Mr. Lowe pleased with the pace of the progress?
Ms. Murray said, objection.
The court said, so he can't speak to how another individual felt.
How long were you in Macau?
Approximately 4 days, 5 days I believe.
And how many total meetings did you have with Joe Lowe?
2.
And did you later return to the U.S.?
Yes, I did.
And after you returned to the U.S., did Joe Lowe continue to send funds as part of this conspiracy?
Yes. It's my understanding that he did, yes.
And do you recall whether he sent you funds after you returned from the trip to Macau?
Yes, he did.
And approximately how much did he send you upon return?
I believe the number was €35 million, which translated to roughly 41 million US that was deposited into my IOLTA account.
And why was it deposited into withdrawn? You referred to an IOLTA account, is that right?
An attorney escrow account.
And why was it sent to your attorney escrow account?
When we were in Macau, there were discussions about ways in which additional money could be sent to the US, and a number of ideas were circulated. One idea involved me being made a trustee or a member of an organization that had one of Joe Lowe's companies that had sufficient funds. Ultimately, that was not the way that they decided to move forward with it. And money was then put in my escrow account, making me the escrow agent so that monies could be distributed from that account.
And was any part of the money that you just referred to intended to be a success fee for the extradition of Mr. Guo?
I wouldn't be able to say specifically that it was a success fee for the extradition of Mr. Guo. I would be able to say that lots and lots of money were coming in, as I've already testified to. I wasn't privy to what payments were going to be made to whom and for what reason. Understand that there were 2 simultaneous projects that were going on in the same time.
In total, you said there were about $100 million for these 2 projects.
I believe it was plus or minus 100 million.
Now, was Mr. Michel ultimately convicted as part of this conspiracy?
Yes, he was.
And did Mr. Broidy plead guilty as part of this conspiracy?
Yes, he did.
And you refer to someone named Ms. Lum Davis?
Yes.
Did Ms. Lum Davis plead guilty as part of this conspiracy?
I believe that she did. I did not know what the outcome of that particular trial was. I heard that that may have been rescinded. But I do not want to testify to that in terms of what the outcome of that case was.
As you testified to before, you 2 pled guilty to a conspiracy count.
Yes, I did.
Mr. Skirrick said, now, Your Honor, at this time I'd like to read a stipulation between the parties.
The court said, all righty.
Mr. Skirrick said, this is what's been marked Defendant's Exhibit Stip 2. And if everyone will just be patient with me for a moment. It is hereby stipulated and agreed by the United States of America and Miles Guo, the defendant, through their attorney of record, that 1. Defense Exhibits DX40017, DX40019, DX40021, DX40024, and DX40037 are true and correct copies of portions of recordings of telephone calls between Mr. Guo and Liu Yanping, LIU. Last name, YANPING, occurring on the following dates. With respect to DX40017, the date of the conversation was May 2, 2017. With respect to DX40019, the date of the conversation was May 4, 2017. DX40021, the date of the conversation was May 10, 2017, for DX40024. The date of the conversation was May 12, 2017, for DX40037, the date of the conversation was January 27, 2017. Defense Exhibits DX40017, T, 40019, T, DX40021, T, DX40024, T and DX40037, T are accurate translations respectively of the underlying exhibits. Defense Exhibits DX40052 and DX40053 are true and correct copies of recordings respectively of the May 23, 2017 and May 24, 2017 meetings between, among others, Mr. Guo and Liu Yanping. Defense Exhibit DX40052-T and DX40053-T are accurate English translations respectively of portion of DX40052 and DX40053. This stipulation and the defense exhibits referenced herein may be received into evidence as defense exhibits at trial signed by the parties. Your Honor, we move the stipulation into evidence at this time.
Ms. Murray said, Your Honor, with respect to the stipulation, we have no objection. With respect to the exhibits that are cited in the stipulation, we also have no objection to their being admitted as redacted.
The court said, so you're seeking the admission of both the stipulation and the referenced exhibits, correct?
Mr. Skirrick said, what Ms. Murray says is correct. We're seeking the admission of the stipulation. And then the redacted transcripts which, in the interest of time, I'm happy to just refer to these and not read them all into the record. They're quite lengthy, Your Honor. Alternatively, I'm happy to read them into the record.
The court said, that's all right. That's all right. So I will admit both the stipulation and the exhibits.
Mr. Skirrick said, thank you, Your Honor. Defendant's Exhibit Stip 1, 40017, 40017, T, 40019, 40019, T, 40021, 40021, T, 4024, 40024, T, 40037, 4037, T, 40052, 40052, T, 40053. 40053, T received in evidence.
By Mr. Skirrick.
If we can please pull up Defense Stip, DX Stip 0001, if we could please blow up paragraph 2. It reads. In 2017, a U.S. law enforcement agency assessed that Mr. Miles Guo was the highest priority of China repatriation efforts. If we can go to paragraph 6 on the following page. Please blow up paragraph 6 if you would. Paragraph 6 reads, since Mr. Guo fled the PRC, the PRC government has sought his return for prosecution in the PRC and has employed numerous methods to effect Mr. Guo's capture or arrest. In May of 2017, the PRC government sent for undeclared agents from the PRC's Ministry of State Security, MSS, to the United States to attempt to cause Mr. Guo's coerced repatriation to the PRC as part of the Fox Hunt Initiative. If we could please pull up DX40019, and publish to the jury. And if we could please go to page 4. Now pursuant to the stipulation that was just entered into evidence. These transcripts were from recordings that were made on May 4, 2017. Mr. Secretary Liu, let me tell you. One thing is about them, the matter of Qingji mother and daughter going to your place. You must be sure not to disclose that. Did you hear me? Okay. 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 Secretary Liu, another thing is about your fourth brother and sixth brother. You must not tell anyone about your fourth brother and sixth brother. No matter who talks about it or asks you about it. You must not give them any direct answer. Okay. Okay. Mr. Guo, look, why are you so confused, Secretary? Maybe you don't know. Let me finish what I'm saying. We are recording some thank you videos every day now, right? I won't talk about the leaders anymore. I'll just record some videos. Probably less than half an hour. After my fourth and sixth brother have boarded a plane in Dalian. If we could please pull up what is now in evidence as DX40021, and please go to the page 2. Pursuant to the stipulation that was just entered into evidence, this is a transcript of a call recording dated May 10, 2017. Mr. Guo, my Twitter and my website were completely hacked by hackers. Oh. I've been in meetings all day and suddenly it's been a mess. I won't say any more. How can these people still keep doing this? Secretary Liu, well, let me tell you. I've already asked about it today. Really asked about it. Over here everything is now following the agreement. Everything stopped. You understand what I mean? Ah, do you understand? You should trust me on this, you know. You should believe what I say. Mr. Guo, understood. I absolutely trust you. Ah. The authorities definitely should be like this. Secretary Liu, and now, you know, about this matter. I'm telling you, you really should say less. If you keep talking like this, you'll offend too many people. Can we please pull up what's in evidence as DX40024T? And go to pages 8 and 9 pursuant to the stipulation that's now in evidence. This is a transcript of a recording between Mr. Guo and Secretary Liu that took place on May 24, 2017. Secretary Liu, I suggest you think big picture, not small picture. If you only focus on the immediate concerns, I think you're being short-sighted. You should think big picture. Plan your entire future life. Seriously consider what to do about this matter, even if we meet. I want to talk about you, I want to talk to you about this, you know, including your immediate concerns. How are you going to deal with them? Your immediate concerns, your family, employees, your business. These domestic enterprises. You must consider all these factors. Understand? Moving to the next page. Secretary Liu continues, it's unrealistic to say you shouldn't consider them. Furthermore, I suggest you also do the math for your future life, understand? Once you have these two aspects sorted out, I think you can find a suitable path for us to move forward together, okay? Otherwise, I think sometimes you're too easily emotionally impulsive. You're eloquent. Mr. Guo, that's my fault. Secretary Liu, exactly. You're eloquent. You speak without restraint, say whatever comes to your mind. But afterwards you know this approach can only offend people. Understand? Trying to solve your problems. If what you say only backfires, what else can you expect? I'm earnestly advising you now. So I'm telling you. Guo Wengui, you are already in your 40s, age of no doubt, and about to enter your 50s. Which is the age of understanding your fate. If we can go to page 12. We're still on the transcript of a recording from May 24, 2017. Secretary Liu, is that okay? I'm saying this entirely for your own good. Furthermore, you said we need to move forward. Well, moving forward has conditions. Right. You can't just say you're moving forward without considering the basic conditions for it. We need a path to move forward, don't we? I can only move forward when we have a path. By doing what you're doing, you're blocking and cutting off our path forward. How can we move forward like this? He continues. Guo Wengui, you're a smart person. I've said my piece. You should understand. Okay. All right. Mr. Guo, okay. I understand. Yes. Secretary Liu, I'm calling you to convey this message. That's all. All right. Mr. Guo, okay. Starting from today, as you just mentioned, you don't allow it. Let me reiterate again. I promised absolutely not to discuss these two leaders. Secretary Liu, yes, yes, yes.
The court said, is that the end of this particular excerpt?
Mr. Skirik said, one more, Your Honor, and we're done.
The court said, okay.
Mr. Skirik said, if we can go to page 15, please. Mr. Guo, do you understand when I meet you later I'll tell you more about it? What this person has brought to you and then about this, they're involved in real estate in Australia. In United States, in Hong Kong. I found out about their funds. They just spent 3 or 4 hours with one of my friends who returned to Hong Kong. Just like what I told you the day before yesterday, that if Guo Wengui dares to mention this, his family will be done for. I hate him so much for threatening me with my family. I hate him. Mr. Guo continues. Then saying it's not safe, saying so much, Secretary, you must consider my perspective. Secretary Liu, let me tell you, hello. Let me tell you. This is like you punching someone and then they kick you back. Do you understand what I mean? If you keep fighting this, when will it end? Mr. Guo, you didn't understand. It's not like that, Secretary. You didn't get it. This is Deputy Secretary and this, Panrui and Panchi matter. It started from the time of Liu Ziwawa. It started from the matter of Liu Ziwawa. I totally forgot about this matter. He's been putting so much effort into it. It's all nonsense. He's threatening my whole family, using my family to threat me. Honestly, Secretary, think about it. What does he want by threatening my family? If it weren't for you, I would yesterday. I tell you again, Secretary, I will accept what you say. Mr. Skirek said, no further questions at time.
The court said, all righty. Members of the jury, it's 2:32. We will resume at 3:02. Don't permit anyone to discuss the case in your presence. Don't read, watch or listen to anything from any source that touches upon the subject matter of this trial. Mr. Higginbotham, you are not to discuss your testimony. You may step out of the courtroom.
Jury not present. Continued on next page. Jury not present.
The court said, please be seated. So how much more do you think you have, Mr. Skirek?
Mr. Skirek said, Your Honor, we've turned over the witness. That's it on direct.
The court said, that's it?
Mr. Skirek said, yes.
The court said, how long do you expect the cross will be?
Ms. Murray said, I think it will be pretty brief, maybe 15 minutes or so.
The court said, okay, so then my instructions. I don't know that I'll be able to get through the amount of pages that we discussed earlier, but I can go as long as I can go.
Ms. Murray said, before we break, Your Honor. Just with respect to limiting instruction we discussed this morning. Perhaps when we come back and we begin cross. We propose that the court give the instruction regarding his employment at DOJ, something to the effect of. You heard testimony that this witness was employed by the Department of Justice during the period he conspired to commit violations of U.S. law. And then you can give the instruction. I instruct you that this prosecution is lawfully brought by the United States of America.
The court said, so did you want to prompt me, or do you want me to just start with that?
Ms. Murray said, happy to have you start with that, Your Honor. And so again. Just kind of led in regarding the testimony they have heard from this witness, and then the request. I instruct you that this prosecution is lawfully brought by the United States of America against Miles Gua.
The court said, okay.
Ms. Murray said, one more point, Your Honor. We wanted to note that we reserve the right to request. Again, depending how defense uses the recordings that were just read into the record during summations. We reserve the right to request a duress instruction for the jury.
Mr. Skirek said, just for the record, we maintain our objection to that, but we understand.
The court said, but you're not making a duress argument, are you?
Mr. Skirek said, Your Honor. I was referring to the instruction that the government is requesting be given during this witness's testimony.
The court said, yes, I understand that. What about the whole duress issue?
Mr. Skirek said, Your Honor, the defense has no intention of making a duress argument as we stated.
Ms. Murray said, yes, Your Honor. I'm noting subject to what happens during summation. The government may renew that request.
The court said, so in addition to my giving the instruction at this time, you're looking for that to be added to the charge?
Ms. Murray said, at this time, Your Honor. I think we'll see how the remainder of this witness goes with respect to cross-examination and redirect. But I know that we put this in front of the court. The court has made a decision subject to what happens and how the defense uses the recordings that it now read into evidence. We think that a duress argument or instruction might be appropriate. There's no specific request at this time. The evidence just came in through this witness, but we're just noting that potential.
The court said, my question was as to the legality of the prosecution. You're asking me to give that instruction now. I'm asking whether or not you're looking to have it included in the final charge.
Ms. Murray said, yes, Your Honor. Excuse me. We're asking for that instruction to be given now and included in the final charge.
The court said, all righty. We will return then at.
Mr. Kumraju said, Your Honor, one minor housekeeping matter. After the defense rest, which we anticipate being after this witness, we're going to renew our Rule 29 motion for the record.
The court said, of course. All righty. The court said, ready? All righty. Please have the jurors come in.
Jury present.
The court said, please be seated. Members of the jury, you have heard that the witness, Mr. Higginbotham, was employed by the Department of Justice I want you to understand that this case that is on trial now, was lawfully brought by the United States of America. You may continue the inquiry. Sir, remember that you're under oath.
Cross-examination. By Ms. Murray.
Mr. Higginbotham, your job at DOJ was as an attorney advisor and congressional liaison, correct?
That is correct.
You had zero involvement in criminal investigations in that role, right?
Zero involvement, that is correct.
And you had zero involvement in criminal prosecutions in that role, correct?
That is correct.
You had zero involvement in asset forfeiture claims in that role, correct?
That is correct, yes.
And while you were working at DOJ, you were not permitted to do legal work for private clients outside of DOJ, correct?
That is correct.
You had no involvement at all with this case against Miles Guo for fraud, correct?
Zero involvement. No involvement at all.
Mr. Higginbotham, you've never met me before, right?
No, I have not.
You've never met any of the other prosecutors on this case, correct?
I do not believe so, no.
None of the prosecutors in this case was involved in prosecuting you, correct?
No, they were not.
You're not a follower of Miles Guo, are you?
No, I am not.
You didn't watch his broadcasts in 2018, right?
No, I did not.
You didn't watch his broadcasts between 2019 and 2023, correct?
Mr. Skirrick said, asked and answered.
The court said, overruled. You may answer.
No, I did not. No, I did not.
You've never followed Miles Guo's accounts on Twitter, right?
No, I have not.
Or on Getter?
No, I have not.
You weren't aware of the GTV Media private placement in April of 2020, correct?
I was not.
You've never invested in GTV Media, right?
No, I have not.
You've never received GTV stock in exchange for any investment, have you?
No, I have not.
You've never loaned money to any of the Himalaya farms, is that correct?
No, I have not.
You've never bought a G Club's membership, right?
No, I have not.
You've never even heard of G Clubs before today?
I have not, no.
You've never invested in any of the G series offerings, correct?
No, I've never heard of them before.
And you've never purchased credits on the Himalaya exchange, isn't that right?
That is correct.
You pled guilty to bank fraud conspiracy, right?
Yes, I did.
You misrepresented the true source and purpose of transfers of tens of millions of dollars, correct?
That is accurate, yes.
You did not tell banks that the money was for, among other things, effort to lobby to have Guo sent to China, right?
That is true.
And you created fake loan agreements in the course of your conduct, right?
Yes, I did.
The purpose of those fake loan agreements was to paper the money transfers, correct?
Yes, it was to provide a cover, so to speak, yes.
To make the transfers seem legitimate, right?
That is accurate.
To deceive the banks, correct?
Yes, that is true.
And there were no actual loans, isn't that right?
No, there were not.
You also created fake contracts, correct?
Yes, I did.
And you did not mention, for example, Joe Low by name in those contracts, right?
No, I did not.
Even though he was the one sending the money?
Yes, that is true.
Because you knew that Joe Low's name would raise red flags with the banks, isn't that right?
Yes.
And you created fake consulting contracts, correct?
That is true.
You created those documents to justify transfers of money to co-conspirators, right?
Yes.
To paper the transactions to make them appear to be legitimate, correct?
That is accurate, yes.
There were no actual consulting services that were provided, isn't that right?
No, there were none.
Ms. Murray said, "May I have a moment, Your Honor?"
The court said yes.
Ms. Murray said, "If we could please pull up what's now in evidence as Defense Exhibit 4017." Mr. Higginbotham, on direct examination, Mr. Skirrick read certain texts from transcripts. Do you recall that?
Yes, I do.
Ms. Murray said, if we could go to page 10, please, Ms. Loftus. And if we could zoom in on the text a little better. We could start with the top half and then the bottom half. Mr. Higginbotham, I'd appreciate if you could help me out here. I'm going to read certain of this language. And I'll have you play the role of Secretary Liu. I'll play the role of Miles Gua. I'll start at the top. From now on, I need to continue to maintain appropriate communication with them. But I will talk about what I have told you without any mention of Secretary Wang, Secretary Meng, or any other central leaders. I'll just talk. I have to talk about Fu Zhenghua. I have to talk about Fu Zhenghua. Do you understand? And then skipping to the next portion of the transcript, again. Miles Gua, you just have to wait a little bit and pause. It should be like this. I'll say 5 sentences today and 4 sentences tomorrow. Then you and I, unintelligible, from today on will no longer mention Secretary Wang, Secretary Meng ever again. And then Mr. Higginbotham, what does Secretary Liu respond?
Okay. Okay.
Miles Gua, do you understand what I mean? I won't mention other leaders either, only Lao Fu. Please allow me time to get off the ramp.
What you mean is that Lao Fu will serve as a ramp to allow us to step down slowly. Is that what you mean?
Miles Gua, yes, 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 that's what I mean. Then when you come, I will say what I want to do now. When you come, what I hope for is that I will no longer act like a villain anymore. Doing things only in the darkness, because that will lead to major events in the future. And I will just need a formal excuse. When I joined, I said at the time that I just wanted to protect my money, my life, and my wealth. Now, the leaders have officially said that a fair and legal solution will be given to the Wenguegua case. And then the next entry, again, Miles Gua, I say, isn't that just telling everyone that I have achieved my goal? I am grateful to the country, and I still love the country and the party.
Okay.
Ms. Murray said, Ms. Loftus, if we could go to page 17 of this exhibit, please.
The court said, and sir, if you'll speak into the microphone, please.
We're going to start at the first full entry here, Mr. Higginbotham, which is Secretary Liu. If you could read the Secretary Liu part begin for me. The third thing I tell you, Secretary, I hope we don't talk about concepts when you come. We should discuss major matters. I just want us to sit down and discuss these specific things. How to solve my problems. Well, how not to hold the press conference. How to turn it into the greatness of our chairman Xi. To turn it into an important turning point event before the 19th National Congress of the Communist Party of China. To promote the rule of law and turn it into such a thing. Ms. Murray said, and Ms. Loftus, if we could go to page 30 of this exhibit, please. And zoom in on the text. And this one is going to start with you, Mr. Higginbotham.
That's it then. We are both gentlemen who are men of our word, brother.
Oh, just watch for the action, just watch for the action.
All right. Okay.
Okay.
Well, okay. That is very good.
Okay.
Okay.
Thank you, Secretary. Thank you, Secretary. Thank you. Thanks. Bye-bye. Ms. Murray said, all right, Ms. Loftus. Can we please now pull up Defense Exhibit 4021 and go to page 4? Here again, Mr. Higginbotham, same roles. I'll start with Miles Gua. I'm not kidding, I did it for you. Secretary. I was really upset. I'm telling you, I did it for you.
Let me tell you, don't ever say you did it for me. We did it to resolve this matter to solve it. Understand? Okay, Is that okay? Hello.
Okay.
Well, that's it then. You should also take care of yourself, you should rest more. Can't keep staying up late like this, okay? All right then, bye.
Ms. Murray said, let's scroll to the next page, please, Ms. Loftus. Okay. Thank you, Secretary.
All right. Goodbye, goodbye.
Okay. Thanks, thanks. Ms. Murray said, finally, Ms. Loftus, Defense Exhibit 4037, page 23, please. If we could zoom in on the text. Again, I'll start as Miles Gua, then 100% he's the one for sure who took our money. From us and our family. And also the police station chief and several others were all present.
All right. Whether you meet him or not, it's up to you. I can't say much about this matter. Understand? Because...
Let's talk after the holiday, after the 5th day of the Chinese New Year.
After the 5th day of the Chinese New Year.
The 5th day of the Chinese New Year. Ms. Murray said, we can zoom out of that, Ms. Loftus, and go to the next page. Zoom in on the text, please. And it picks up with you, Mr. Higginbotham.
Okay, after that. So about these 2 days. I'll turn off my phone at night Beijing time and London time and turn it on in the morning. Generally speaking. Well, as long as it aligns with your time, our time, all right. If there's anything, just send a message first.
Okay. My phone is always on.
Right. If there's anything, send a message first and then we can talk. All right.
Okay, okay.
All right. Let's leave it at that, okay?
Okay. Happy Chinese New Year.
All right. Take care of yourself. Happy Chinese New Year. Happy Chinese New Year. All right. Goodbye, goodbye.
Okay. Goodbye, Secretary. Goodbye. Ms. Murray said, and we can take that down, Ms. Loftus. May I have a moment, Your Honor?
The court said yes.
Counsel conferred.
Ms. Murray said, nothing further. Thank you.
The court said redirect.
Mr. Skirrick said, thank you, Your Honor.
Redirect examination. By Mr. Skirrick.
Briefly, Mr. Higginbotham. Do you understand that you were subpoenaed here today to testify about the conspiracy you were involved in to extradite Mr. Guo?
Yes.
Ms. Murray said, objection.
Do you understand? Mr. Skirrick said, I'm sorry.
The court said, was that an objection?
Ms. Murray said, yes, Your Honor.
Mr. Skirrick said, asking his understanding of why he's here today.
Ms. Murray said, he's testified on direct he's here because he received a subpoena.
The court said, sustained.
Mr. Skirrick said, it's redirect.
By Mr. Skirrick.
You don't know anything one way or the other about the facts of this case, right, Mr. Higginbotham?
No, I do not.
Okay. Now, Ms. Murray read some portions of transcripts to you, do you recall that?
Yes, I do.
Okay. Did you understand that Mr. Guo was negotiating with a CCP representative for his life in these transcripts?
Ms. Murray said, objection, Your Honor.
The court said, overruled.
No, I did not.
Did you understand that Secretary Liu was a representative of the CCP who was trying to lure Mr. Guo back to China?
Ms. Murray said, objection to the testifying, Your Honor.
The court said you may answer.
No, I did not.
Did you understand that ultimately Mr. Guo never returned to China?
Yes.
Thank you. Mr. Skirrick said, no further questions.
Ms. Murray said, nothing further. Thank you.
The court said, thank you, sir. You may step out of the courtroom.
Witness excused.
Mr. Skirrick said, sorry, Your Honor, one moment.
Mr. Kumraju said, thank you, Your Honor. The defense rests.
The court said, please step up.
Ms. Murray said, Your Honor, briefly, before we step up.
The court said, oh.
Ms. Murray said, Just for the record, the government does not have a rebuttal case.
The court said okay.
At sidebar.
The court said, first, I want to give my ruling on two outstanding motions. The government's motion with respect to an instruction that the operation of continuing businesses, the requested instruction with respect to ongoing businesses, as well as the request that I include the instruction that the prosecution is lawful in the jury charge. Both of those are denied.
Mr. Kumraju said, okay.
Ms. Murray said, Your Honor, one additional request that we have, in light of the redirect that just took place. The government again requests a duress instruction. Because Mr. Skirek just clearly asked whether in the evidence that they've introduced, Mr. Guo was negotiating for his life with a Chinese Communist Party official.
Mr. Kumraju said, a duress defense requires that the proffered evidence be offered as an explanation for the underlying criminal activity. That's not what we're doing. We're not saying that he was doing it out of a threat for his life, that he engaged in GTV or G clubs or any of those things. So there's no duress defense that's being offered.
Mr. Finkel said, Your Honor, that's exactly why it's appropriate for Your Honor to tell the jury that. The jury does not know what defense counsel just said. The jury does not know the law. There is no duress defense here. But the jury might think there is, because they are lay people, and they don't know the law. The defense has said numerous times that they are not making a duress defense. It would be very simple. I don't think why they would even object to it if they are not making a duress defense for Your Honor to tell the jury that Miles Guo's actions were not done under duress. There's no duress defense here. Why is that objectionable?
Mr. Kumraju said, because it's confusing to the jury to inject an issue like duress that they've heard nothing about from either the court, the government, or the parties into the jury deliberations for no reason. A duress defense is an affirmative defense which we have to proffer pre-trial. We did not do that. Duress is not an issue at trial. So I don't know why we would inject that issue into the jury's mind. They are going to hear what I say. If after I say it, the government thinks that I've brought up a duress defense, then they have the option to ask again.
Mr. Finkel said, just to be clear about what the government is requesting. It's not requesting a charge on how to prove the affirmative defense of duress. That's not what we want. There is no duress defense here. What we are asking for is Your Honor to tell the jury there is no duress defense, which is to say Guo's actions were not taken out of necessity. They can't be justified as a result of the fact that he was, as Mr. Skirek put it, negotiating for his life. The jury might not know how to deal with that. So we ask Your Honor to just simply tell the jury there is no duress defense.
The court said, so I don't think that it is appropriate and necessary, so the application is denied.
Mr. Kumraju said, thank you, Your Honor. Your Honor, at this time, after the close of the defense case, the defense would renew its Rule 29 motion on the same basis as previously asserted, in the interest of time.
Mr. Finkel said, we oppose it. We're happy to provide additional information. But I believe there's more than sufficient evidence for this case to go to the jury. It's consistent with Your Honor's ruling at the close of our case that the Rule 29 application should be denied. We're happy to explain more, if Your Honor would like.
The court said, so I denied the application, but permitted the defense to submit papers within the time allowed under the rules.
Ms. Strofa said, Your Honor, the time is 7 days. May we have 30 days?
Mr. Kumraju said, right. I think also we have to renew it after the defense case in order for the defense case to be part of the appeal, in the event of a conviction. So I think that's the reason why we're renewing it now orally. And then I assume, if there is a jury verdict of guilt on any of the counts, then we would ask for that verdict to be set aside at that point and ask for a briefing schedule.
The court said, so you're not looking for anything at this point.
Mr. Kumraju said, well, I'm renewing the Rule 29, so I am making that motion.
The court said, "No, but I'm saying you're not."
Mr. Kamraju said, "I'm not asking for a briefing schedule or anything at this point. I think we'll wait to see if there's a verdict. If there's a verdict, then we're going to ask Your Honor for a briefing schedule, when we renew that motion again. That's all."
The court said, "Okay. Anything further?"
Ms. Murray said, "No, Your Honor."
Mr. Finkel said, "No."
The court said, "Okay."
Mr. Finkel said, "We did it. Sort of."
In open court.
The court said, "Members of the jury, both sides have rested and have finished presenting evidence. Before the government and the defense deliver their closing arguments, I will instruct you as to the laws, rules, and principles of law that will guide you during your deliberations and rendering your verdict. Tomorrow the government will make its summation first and the defense will follow. After the parties' summations, I will provide you with my final instructions on deliberations. Please turn to page 4 of the jury charge. As I read aloud, I would like you to read silently to yourselves. We will start with section 1, titled Role of the Court. Members of the jury, we are now approaching the most important part of this case, your deliberations. It has been obvious to me and to counsel that until now, you have faithfully discharged your duty to listen carefully and to observe each witness who testified. I ask that you give me that same careful attention as I read these instructions. You have now heard all the evidence in the case as well. Well, no. You have not yet heard the final arguments of the lawyers, but you will be hearing them. My duty at this point is to instruct you on the law. It is your duty as jurors to follow the law as I state it, and to apply the law to the facts as you find them from the evidence presented. On these legal matters, you must take the law as I give it to you. If an attorney has stated a legal principle different from any that I state to you in my instructions, it is my instructions that you must follow. Moreover, you should not single out any instruction as alone stating the law. Instead, you should consider my instructions as a whole when you retire to deliberate in the jury room. You should not, any of you, be concerned about the wisdom of any rule that I state, regardless of any opinion that you may have as to what the law may be or what it should be. It is your sworn duty to base your verdict upon the law as I give it to you. Your final role is to pass upon and decide the factual issues in this case. You, the members of the jury, are the sole and exclusive judges of the facts. You pass upon the weight of the evidence. You determine the credibility of the witnesses. You resolve such conflicts as there may be in the testimony. And you draw whatever reasonable inferences you decide to draw from the facts as you have determined them. I shall later discuss with you how to determine the credibility or believability of the witnesses. In determining the facts, you must rely upon your own recollection of the evidence. What the lawyers have said in their opening statements, what they will say in their closing arguments, and in their objections is not evidence. Nothing that I may have said during the trial or may say during these instructions constitutes evidence. Questions asked by the attorneys or even myself are not, in and of themselves, evidence. Only questions coupled with answers are evidence. Therefore, you may not infer any fact from the mere asking of a question. Moreover, you may not consider any answer that I directed you to disregard or that I directed struck from the record. The evidence in this case consists of the sworn testimony of the witnesses on both direct and cross-examination, the exhibits received in evidence, and the stipulations of the parties. By contrast, you may not consider exhibits that were marked for identification or any other document you may have seen but not received as evidence. Only those exhibits actually received may be considered as evidence. Similarly, testimony that has been excluded, stricken, or that you have been instructed to disregard is not evidence and must be ignored. Some evidence has been received for limited purposes only. When I have given you a limiting instruction as to such evidence, you must follow that instruction and consider such evidence for only the limited purpose that I allowed. Obviously, anything you may have seen or heard outside the courtroom is not evidence. Nothing I said or did should be used by you to determine whether the government has met its burden of proof. I have no view as to whether the government has met its burden, and you should not infer that I do from anything that I said or did. You should draw no inference or conclusion for or against any party by reason of lawyers making objections. Counsel have not only the right, but the duty, to make legal objections when they think that such objections are appropriate. Also, do not draw any inference from any of my rulings. The rulings I make during trial are not an indication of my views of what your decision should be as to whether or not the defendant has been proven guilty beyond a reasonable doubt. You should draw no inference or conclusion of any kind, favorable or unfavorable, with respect to any witness or any party in the case, by reason of any comment, question, or instruction of mine. One moment. The defendant has pleaded not guilty to the charges in the indictment. The indictment itself is not evidence. It merely contains the charges that the government must prove beyond a reasonable doubt. The government is not required to prove each and every allegation in the indictment. The government is required to prove only the elements of the charges contained in the indictment, which I will explain to you shortly. Because the defendant has pleaded not guilty, the burden is on the prosecution to prove guilt beyond a reasonable doubt. This burden always remains with the government and never shifts to the defendant. Indeed, the law never imposes upon a criminal defendant the burden of proving his innocence or even the duty of calling any witnesses or producing any evidence at all. The law presumes a defendant innocent of all charges against him. I therefore instruct you that you must presume the defendant innocent throughout your deliberations until such time, ever, that you as a jury are unanimously satisfied that the government has proven the defendant's guilt beyond a reasonable doubt. The defendant began the trial with a clean slate. This presumption of innocence alone is sufficient to acquit unless you are unanimously convinced beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence against him. If the government fails to overcome the presumption of innocence, and does not sustain its burden of proving guilt beyond a reasonable doubt with respect to the defendant, you must find the defendant not guilty. The presumption of innocence was with the defendant when the trial began and remains with him even now as I speak. It will continue into your deliberations, unless and until you are convinced that the government has proven the defendant's guilt beyond a reasonable doubt. In determining whether the government has satisfied its burden of proving the defendant's guilt beyond a reasonable doubt, you may consider all the evidence presented, whether by the government or the defense. In doing so, remember that even though the defendant may have introduced evidence, the burden of proof remains on the government. I said that the government must prove the defendant's guilt beyond a reasonable doubt. The question then is, what is reasonable doubt? The words almost define themselves. It is doubt based upon reason and common sense. It is doubt that a reasonable person has after carefully weighing all of the evidence. It is doubt which would cause a reasonable person to hesitate to act in a matter of importance in his or her personal life. Proof beyond a reasonable doubt must, therefore, be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. A reasonable doubt is not a caprice or whim. It is not a speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. In a criminal case, the burden is at all times on the government to prove guilt beyond a reasonable doubt. The law does not require that the government prove guilt beyond all possible doubt or to a mathematical certainty. On the other hand, it is not sufficient to prove that the defendant is probably guilty. Proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of the defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed the crime. A reasonable doubt may arise from evidence or lack of evidence. After fair and impartial consideration of all the evidence, you are satisfied of the defendant's guilt beyond a reasonable doubt as to the charge you are considering. You must find the defendant guilty. On the other hand, if, after fair and impartial consideration of all the evidence, you have a reasonable doubt, you must find the defendant not guilty of that charge. There are two types of evidence which you may properly use in deciding whether the defendant is guilty or not guilty of the charged crimes: direct and circumstantial evidence. Direct evidence is evidence that proves a disputed fact directly. For example, where a witness testifies to what he saw or heard or observed, that is called direct evidence. Circumstantial evidence, by contrast, is evidence that tends to prove a disputed fact by proof of other facts. To remind you of the example that I gave you at the beginning of the trial, Suppose that when you came into the courthouse today the sun was shining and it was a nice day, but the courtroom shades were drawn and you could not look outside. Then later, as you were sitting here, someone walked in with a dripping wet umbrella, and soon after, someone else walked in with a dripping wet raincoat. Now, on our assumed facts, you cannot look outside of the courtroom and you cannot see whether or not it is raining. So you have no direct evidence of that fact. But on the combination of the facts about the umbrella and the raincoat, it would be reasonable for you to conclude that it had been raining. That is all there is to circumstantial evidence. Using your reason and experience, you infer from established facts the existence or non-existence of some other fact. Many material facts, such as a person's state of mind, are not easily proved by direct evidence. Usually, such facts are established by circumstantial evidence and the reasonable inferences you draw. Circumstantial evidence is of no less value than direct evidence. For it is a general rule that the law makes no distinction between direct and circumstantial evidence, but simply requires that before convicting a defendant, the jury must be satisfied of the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Now, whether the circumstantial evidence leads you inevitably to a particular inference is another matter. Let me give you another example. Let's say that one evening you go into a subway station. It's a local stop and it's not rush hour. You arrive at the platform and you are surprised to find a large crowd of people waiting on the platform. You didn't expect there to be so many people, but there are lots of people waiting. Now, you might infer from this fact that there must not have been a train for quite some time. But is that an inference you must draw from the circumstantial evidence of a crowded subway platform? It is certainly a weaker inference than the one about the umbrella and the raincoat. Because if you think more about it, maybe there are other equally plausible explanations. Maybe there was a train just a minute ago that went out of service and they said, "Everybody off the train." Or maybe it's 10:30 p.m. and you're waiting at the 50th Street stop of the number 1 train, and a Broadway show has just let out. There is more than one plausible explanation. So in this example, you wouldn't have as strong a basis for drawing any one particular inference. It must be clear to you by now that counsel for the parties are asking you to draw very different conclusions about some of the factual issues in this case. An important part of that decision will involve making judgments about the testimony of the witnesses you listened to and observed. In making these judgments, you should carefully scrutinize all of the testimony of each witness, the circumstances under which each witness testified, and any other matter and evidence that may help you to decide the truth and the importance of each witness's testimony. Your decision whether or not to believe a witness may depend on how that witness impressed you. Was the witness candid, frank, and forthright, or did the witness seem to be evasive or suspect in some way? How did the way the witness testified on direct examination compare with how the witness testified on cross-examination? Was the witness consistent or contradictory? Did the witness appear to know what he or she was talking about? Did the witness strike you as someone who was trying to report his or her knowledge accurately? What was the witness's demeanor like? These are examples of the kinds of common-sense questions you should ask yourselves in deciding whether a witness is or is not truthful. In addition, you may consider whether a witness had any possible bias or relationship with the party, or any possible interest in the outcome of the case. Such a bias or relationship does not necessarily make the witness unworthy of belief. These are simply factors that you may consider. If a witness made statements in the past that are inconsistent with his or her testimony during the trial concerning facts that are at issue, you may consider that fact in deciding how much of the testimony, if any, to believe. In making this determination, you may consider whether the witness purposefully made a false statement and whether it was, or whether it was an innocent mistake. You may also consider whether the inconsistency concerns an important fact or merely a small detail, as well as whether the witness had an explanation for the inconsistency and, if so, whether that explanation appealed to your common sense. If you find that a witness has testified falsely as to any material fact, or if you find that a witness had previously been untruthful when testifying under oath or otherwise, you may reject that witness's testimony in its entirety, or you may accept only those parts that you believe to be truthful, or that are corroborated by other independent evidence in the case. You should also consider whether the witness had an opportunity to observe the events he or she testified about, and whether the witness's recollection of the facts stands up in light of other evidence in the case. In other words, what you must try to do in deciding credibility is to size up a person, just as you would in any important matter where you are trying to decide if a person is truthful, straightforward, and accurate in his or her recollection. Now, a witness may be discredited or impeached by contradictory evidence or by evidence that at some other time the witness had said or done something that is inconsistent with the witness's present testimony. The earlier inconsistent or contradictory statements are admissible only to discredit or impeach the credibility of a witness, not to establish the truth of earlier statements made somewhere else. You may also consider a witness's earlier silence or inaction that is inconsistent with his or her courtroom testimony to determine whether the witness is impeached. If you believe that any witness has been impeached and, thus, discredited, then it is for you to give the testimony of that witness as much or as little weight, if any, as you think it deserves. You are not required to accept testimony even though the testimony is uncontradicted, and the witness's testimony is not challenged. You may reject it because of the witness's bearing or demeanor, or because of the apparent improbability of the testimony, or for other reasons sufficient for you to conclude that the testimony is not worthy of belief. It is for you, the jury, and for you alone, not the lawyers or the witnesses or me as the judge, to decide the credibility of witnesses who appeared here and the weight that their testimony deserves. I refer to the two separate decisions that the jury must make in evaluating witnesses: credibility and weight. When you decide whether you believe what a witness says, you decide credibility. When you decide how much to allow that evidence to affect your decision on any issue, you decide the weight to give the testimony. In evaluating the credibility of the witnesses, you should take into account any evidence that the witness who testified may benefit in some way from the outcome of this case. Such an interest in the outcome may create a motive to testify falsely, and may sway the witness to testify in a way that advances his or her interests. Therefore, if you find that any witness whose testimony you are considering may have an interest in the outcome of this trial, then you should bear that factor in mind when evaluating the credibility of his or her testimony, and accept it with great care. This is not to suggest that a witness who has an interest in the outcome of a case will testify falsely. It is for you to decide to what extent, if at all, the witness's interest has affected or colored his or her testimony. You are to perform the duty of finding the facts without bias or prejudice as to any party. You are to perform your final duty in an attitude of complete fairness and impartiality. The case is important to the government, for the enforcement of United States criminal laws is a matter of prime concern to the community. Equally, it is important to the defendant who is charged with serious crimes. The fact that the prosecution is brought in the name of the United States of America entitles the government to no greater consideration than that accorded to any other party to a litigation. By the same token, it is entitled to no less consideration. The parties, whether the government or an individual, stand as equals at the bar of justice. Under your oath as jurors, you are not to be swayed by sympathy. You are to be guided solely by the evidence in this case. And the crucial question that you must ask yourselves as you sift through the evidence is, has the government proven the guilt of the defendant beyond a reasonable doubt? It is for you and you alone to decide whether the government has proven that the defendant is guilty of the crimes charged, solely on the basis of the evidence and subject to the law as I instruct you. It must be clear to you that once you let fear, prejudice, bias, or sympathy interfere with your thinking, there is a risk that you will not arrive at a true and just verdict. If you have a reasonable doubt as to the defendant's guilt, you should not hesitate to find the defendant not guilty. But, on the other hand, if you find that the defendant has met its burden of proving the defendant's guilt beyond a reasonable doubt, you should not hesitate to find the defendant guilty. Under your oath as jurors, you cannot allow a consideration of possible punishment that may be imposed upon the defendant, if convicted, to influence you in any way or to enter into your deliberations. The duty of imposing sentence is mine, and mine alone. Your function is to weigh the evidence and to determine whether the defendant is or is not guilty based on the evidence and the law. Therefore, I instruct you to not consider punishment or possible punishment during your deliberations. The defendant, Miles Gua, also known as Ho Wan Kwok and Gua Wan Goe, has been charged in an indictment. The indictment is a document containing the charges or counts against the defendant. It is not evidence or proof of the defendant's guilt. You are directed to not consider or discuss how the indictment was obtained. Before you begin your deliberations, you will be provided with a copy of the indictment. Therefore, I will not read the entire indictment to you at this time. Instead, I will summarize in general terms the offenses charged. Then I will explain in detail the elements of those offenses. An element is an essential component of an offense. You must find that the government established all elements of an offense beyond a reasonable doubt to find the defendant guilty of that offense. The indictment contains 12 charges or counts against the defendant, each of which is alleged to have occurred between 2018 and March 2023. The government alleges that the defendant operated 4 fraudulent investment schemes as part of a criminal enterprise. The term criminal enterprise is also referred to as a racketeering or RICO enterprise. Count 1 charges the defendant with conspiracy to operate a criminal enterprise. Counts 2, 3, and 4 charge the defendant with conspiracy to commit wire fraud, bank fraud, securities fraud, and money laundering. Counts 5 and 6 charge the defendant with securities fraud and wire fraud in connection with the private stock offering for the media company, known as GTV. Counts 7 and 8 charge the defendant with wire fraud and securities fraud in connection with the farm loan program. Counts 9 and 10 charge the defendant with wire fraud and securities fraud in connection with G-Clubs. Count 11 charges the defendant with wire fraud in connection with the Himalaya exchange. Finally, Count 12 charges the defendant with making a $100 million wire transfer, using money derived from a crime. In a moment, I will instruct you on each of these charges in more detail. As I said, the indictment contains a total of 12 counts against the defendant. Each count constitutes a separate alleged crime. You must consider each count of the indictment separately, and you must return a separate verdict on each count in which the defendant is charged. Whether you find the defendant guilty or not guilty as to one offense should not affect your verdict as to any other offense charged. As I just described, certain counts in the indictment are conspiracy counts, and others are what are referred to as substantive counts. A conspiracy charge, generally speaking, alleges that 2 or more persons agreed to commit a crime. The focus of a conspiracy count, therefore, is on whether there was an unlawful agreement. So even if a conspiracy fails and the crime is not actually committed, the conspiracy is still punishable as a crime. A substantive charge, by contrast, is based on the actual commission of an offense. A substantive offense, therefore, may be committed by a single person, and it need not involve an agreement with anyone else. If a defendant both agrees to commit a crime and then actually commits the crime, that defendant may be guilty of both the conspiracy and the substantive crime. Let me first turn to the substantive counts, which are listed as counts 5 through 12 in the indictment. Then I will address the conspiracy counts. Counts 5, 7, 9, and 11 charge the defendant with committing wire fraud, in violation of Title 18, United States Code, Section 1343. Each wire fraud count relates to a separate alleged scheme. Count 5 alleges that the defendant conducted the GTV private placement to sell GTV stock, and fraudulently obtain money from individuals by making false statements and misrepresentations, including, among other things, about how their money would be used. Count 7 alleges that the defendant conducted the farm loan program to fraudulently obtain money from individuals by making false statements and misrepresentations, including, among other things, about how the farm loans participants' money would be used. Count 9 alleges that the defendant promoted and marketed G-Clubs to fraudulently obtain money from individuals by making false statements and misrepresentations, including, among other things, about how the money individuals sent to G-Clubs would be used. And Count 11 alleges that the defendant operated the Himalaya exchange to fraudulently obtain money from individuals through false statements and misrepresentations, including, among other things, about how money sent to the Himalaya exchange would be used. In order to find the defendant guilty of wire fraud, the government must prove the following 3 elements beyond a reasonable doubt. First, that there existed a scheme or artifice to defraud or to obtain money or property by means of materially false or fraudulent pretenses, representations, or promises. Second, that the defendant knowingly, willfully, and with the intent to defraud, devised or participated in the scheme or artifice. Third, that an interstate or foreign wire communication was used in furtherance of the scheme or artifice. I'll describe each of these elements in greater detail now. The first element of wire fraud that the government must prove beyond a reasonable doubt is that there was a scheme or artifice to defraud or to obtain money or property by means of materially false or fraudulent pretenses, representations, or promises. A scheme or artifice is just a plan to accomplish an objective. So a scheme or artifice to defraud is any plan to deprive another of money or property by means of false or fraudulent pretenses, representations, or promises. A pretense, representation, or promise is false if it is untrue when made and was at the time known to be untrue by the person making it. And it is fraudulent if it was made with intent to deceive. A representation, statement, claim, or promise may also be false or fraudulent if it contains half-truths, or if it deliberately conceals material facts, in a manner that makes what is said or represented misleading or deceptive. The false or fraudulent representation must relate to a material fact or matter. A material fact is one which would be expected to be of concern to a reasonable and prudent person in relying upon the representation or statement in making a decision. That means that if you find that a particular statement or representation was false, you must determine whether that statement or representation was one that a reasonable person would have considered important in making his or her decision. The same principle applies to fraudulent half-truths or omissions, that is, failures to disclose facts. The government does not have to prove that any person actually relied on or suffered damages as a consequence of any fraudulent representation or concealment of facts. Nor do you need to find that the defendant profited from the fraud. It is enough that a false statement, half-truth, or omission was made as part of a fraudulent scheme with the expectation that it would be relied on. You must concentrate on whether there was such a scheme, not on whether the scheme succeeded. Fourth, proof that the scheme succeeded may be the most persuasive evidence of the existence of the scheme itself. In determining whether a scheme to defraud existed, it is irrelevant whether a victim might have discovered the fraud if he, she, or it had looked more closely or probed more extensively. A victim's negligence or gullibility in failing to discover a fraudulent scheme is not a defense to wire fraud.
Continued on next page.
The court said, a scheme to defraud need not be shown by direct evidence, but may be established by the circumstances and facts in the case. B. Second element. Knowledge and intent to defraud. The second element that the government must prove beyond a reasonable doubt for the wire fraud counts is that the defendant devised or participated in the scheme to defraud knowingly, willfully, and with the specific intent to defraud. I will now define these terms. To devise a scheme to defraud is to concoct or plan it. To participate in a scheme to defraud means to associate oneself with it, with the intent to making it succeed. Although a mere onlooker is not a participant in a scheme to defraud, it is not necessary that a participant be someone who personally and visibly executes the scheme. To act knowingly means to act voluntarily and deliberately, rather than mistakenly or inadvertently. To act willfully means to act voluntarily, and with the wrongful purpose. An act is done knowingly and willfully if it is done purposefully and deliberately. That is, the defendant's act must have been the product of the defendant's conscious determination rather than the product of a mistake, accident, mere negligence, or some other innocent reason. To act with a specific intent to defraud requires that the defendant engaged or participated in the fraudulent scheme with awareness of its fraudulent or deceptive character, with an intention to be involved in the scheme to defraud and to help it succeed, and with the purpose of obtaining money or property from another. Now, science has not yet devised a manner of looking into a person's mind and knowing what that person is thinking. However, you have before you evidence of certain acts, conversations, and statements alleged to have been made by, with, or in the presence of the defendant and others. The ultimate facts of knowledge and criminal intent may be established by words, conduct, and all the surrounding circumstances, as well as the rational or logical inferences that may be drawn from the words and conduct. The defendant need not have participated in or had knowledge of all of the operations of the scheme in order to have acted with knowledge and intent. It is for you to determine whether the government has established beyond a reasonable doubt such knowledge and intent on the part of the defendant. Direct proof of knowledge and fraudulent intent is almost never available. It would be a rare case where it could be shown that a person wrote or stated that, as of a given time in the past, He committed an act with fraudulent intent. Such direct proof is not required. Instead, the ultimate facts of knowledge and criminal intent, though subjective, may be established by circumstantial evidence, based upon a person's outward manifestations, his words, conduct, and acts, and all the surrounding circumstances disclosed by the evidence and the rational or logical inferences that may be drawn from them. Additionally, it is not necessary for the government to prove that the defendant was motivated solely by improper considerations. A defendant may have the required intent to defraud, even if the defendant was motivated by other lawful purposes as well. Because an essential element of the crime charged is intent to defraud, it follows that good faith on the part of a defendant is a complete defense to a charge of substantive wire fraud. A defendant acts in good faith when he honestly believed at the time that the representations he was making were true, even if they turned out to be inaccurate or false. However, in considering good faith, the fact that a defendant believes, rightly or wrongly, that he will ultimately be able to work things out so that no individual suffers a loss is no excuse for the real and immediate loss resulting from the defendant's fraudulent conduct. The burden is on the government to prove fraudulent intent and the consequent lack of good faith beyond a reasonable doubt. C. Third element. Interstate wires. The third and final element of substantive wire fraud is that an interstate wire was used in furtherance of the scheme to defraud or to obtain money or property by means of materially false or fraudulent pretenses, representations, or promises. A wire can be, for example, a phone call, email communication, text message, social media or website post, or a bank wire transfer. The wire must be an interstate wire, that is, it must pass between two or more states or a state and a foreign country. The use of the wire need not itself be a fraudulent representation. It must, however, further or assist in some way in carrying out the scheme. A wire communication can also include a communication made after an individual's funds were obtained. It is not necessary for the defendant to have been directly or personally involved in a wire, as long as the wire was reasonably foreseeable in the execution of the scheme to defraud. In this regard, it is sufficient to establish this element of the crime if the evidence justifies a finding that the defendant caused the wire to be used by others. The wire requirement can be satisfied even if the wire was used by the person being defrauded or some other party. When one does an act with knowledge that the use of a wire will follow in the ordinary course of business, or where such use of a wire reasonably can be foreseen, even though not actually intended, then he causes a wire to be used. There is no requirement that the defendant specifically authorize others to use a wire. Only the use of a wire must be reasonably foreseeable, not its interstate or foreign component. If you find that the wire that occurred was reasonably foreseeable, then this element is satisfied even if it was not foreseeable that the wire would cross state or national lines. 17. Elements of Counts 6, 8, and 10. Securities fraud. Counts 6, 8, and 10 of the indictment charge the defendant with securities fraud in violation of Section 10(b) of the Securities Exchange Act and the related Rule 10b-5. In particular, Count 6 alleges that the defendant conducted the GTV private placement to sell GTV stock and obtain money from victims through false statements and misrepresentations, including, among other things, about how the GTV investors' money would be used. Count 8 alleges that the defendant conducted the farm loan program to obtain money from victims through false statements and misrepresentations, including, among other things, about how the farm loans participants' money would be used and that such loans would be convertible into GTV common stock. Count 10 alleges that the defendant promoted and marketed G-clubs to obtain money from victims through false representations and misrepresentations, including, among other things, about how the G-clubs members' money would be used, and that their purchase of G-clubs memberships would entitle them to stock in GUI-affiliated entities. To prove these charges, for each of the three securities fraud counts, GTV, the farm loans program, and G-clubs, the government must prove each of the following three elements beyond a reasonable doubt. First, that in connection with the purchase or sale of shares in GTV, G-Fashion, or some other purported security, the defendant did any one or more of the following. 1. Employed a device, scheme, or artifice to defraud. 2. Made an untrue statement of a material fact or omitted a material fact which made what was said, under the circumstances, misleading. Or 3. engaged in an act, practice, or course of business that operated, or would operate as a fraud or deceit upon a purchaser or seller. Second, that in doing so, the defendant acted knowingly, willfully, and with the intent to defraud. And third, that in doing so, the defendant used or caused to be used any instrumentality of interstate commerce. I will discuss each of these elements in greater detail now. First element, fraudulent act. The first element of securities fraud is that, in connection with the purchase or sale of a security, the defendant did any one or more of the following. 1. Employed a device, scheme, or artifice to defraud. 2. Made an untrue statement of a material fact or omitted to state a material fact which made what was said, under the circumstances, misleading. Or 3. Engaged in an act, practice, or course of business that operated, or would operate, as a fraud or deceit upon a purchaser or seller. It is not necessary for the government to prove that the scheme involved all three types of unlawful conduct. Any one will be sufficient to satisfy this element of the offense. You must, however, be unanimous as to which type of unlawful conduct, if any, occurred. When we talked about the elements of wire fraud, I instructed you on what constitutes a scheme or artifice to defraud, and what constitutes a false or fraudulent statement. See pages 17 to 18. You should apply those same instructions here. I will now tell you more about several definitions that are specific to the securities fraud context. Materiality in the securities fraud context. A statement or omission may be material if a reasonable investor would have viewed the information as having significantly altered the total mix of information then available. Material facts include those which may affect the desire of investors to buy or sell a security. Material facts also include facts which, viewed objectively, might affect the value of a security. Materiality is judged as of the time the information was disclosed or omitted. The government does not need to establish that anyone actually relied on the misrepresentation. The government is also not required to prove that the scheme or artifice actually succeeded, that is, that anyone suffered any loss or that the defendant realized any gain. It is the scheme that the law condemns. 2. Security. There are two additional components to the first element of securities fraud. They are that the alleged fraudulent content here with respect to GTV, the farm loans and G clubs, was in connection with the purchase or sale of a security. The term security is defined in the statute that makes securities fraud a crime. It includes, among other things, any stock investment contract, participation in any profit-sharing agreement, or, in general, any instrumentality commonly known as a security. It also includes any right to purchase any of the instruments I just named. An investment contract means a contract transaction or scheme involving an investment of money in a common enterprise with the expectation that profits will be derived solely from the efforts of the promoter or a third party. 3. In connection with. Finally, a scheme to defraud is in connection with the security if you find that the conduct touched upon a purchase or sale of securities. It is not necessary for you to find that the defendant actually purchased or sold securities, nor is it necessary that any security was ever issued or sold. It is sufficient if the defendant participated in a scheme that involved the purchase or sale of securities by another person or entity. The government need not prove that the defendant agreed to personally make a misrepresentation or omit a material fact. It is sufficient if the government establishes that the defendant intended to cause the statement to be made or the fact to be omitted. Likewise, you need not find that the defendant actually participated in any specific purchase or sale of a purported security if you find that the defendant participated, or agreed to participate, in the fraudulent conduct that was in connection with the purchase or sale of securities. B. Second element. Knowledge, intent, and willfulness. The second element of securities fraud that the government must establish is that the defendant acted knowingly, willfully, and with intent to defraud. I defined these terms for you when we discussed the wire fraud charges. See pages 19-20. So I will not discuss them at length here. Briefly, knowingly means to act voluntarily and deliberately, rather than mistakenly or inadvertently. To act willfully means to act voluntarily, and with a wrongful purpose. Intent to defraud means to act knowingly, and with intent to manipulate or deceive. In order for you to find the defendant guilty of securities fraud, the government needs to prove that the defendant acted with an intent to deceive, manipulate, or defraud. But the government need not show that the defendant acted with an intent to cause harm, because an essential element of the crime charged is intent to deceive or intent to manipulate. Good faith on the part of the defendant is a complete defense to the charge of securities fraud. A defendant acts in good faith when he honestly believed at the time that the representations he was making were true, even if they turned out to be inaccurate or false. However, the fact that a defendant believes, rightly or wrongly, that he will ultimately be able to work things out so that no individual suffers a loss is no excuse for the real and immediate loss resulting from the defendant's fraudulent conduct. A defendant has no burden to establish a defense of good faith. It is the government's burden to prove a lack of good faith by establishing, beyond a reasonable doubt, that the defendant acted knowingly, willfully, and with intent to defraud. C. Third element. Instrumentality of interstate commerce. The third and final element of securities fraud is that the defendant knowingly used, or caused to be used, an instrumentality of interstate commerce in furtherance of the scheme to defraud. This element may be established if the government proves beyond a reasonable doubt that any means or instrumentality of interstate commerce or communication, including the mails, an interstate or international telephone call or email, or an interstate or international wire transaction, were used in furtherance of the scheme to defraud. The government need not prove that the defendant was directly or personally involved in the use. Instead, it is enough if the defendant was an active participant in the scheme and took steps or engaged in conduct that he knew or could reasonably foresee would naturally and probably result in the use of an instrumentality of interstate or foreign commerce. The use of an instrumentality of interstate or foreign commerce need not be central to the execution of the scheme or even incidental to it. All that is required is that the use has some relation to the object of the scheme or fraudulent conduct. 18. Count 12. Unlawful monetary transaction. Count 12 charges the defendant with engaging in a monetary transaction over $10,000 in property derived from specified unlawful activity here. A transaction of approximately $100 million derived from the GTV private placement to a private investment fund in violation of Title 18, United States Code, Section 1957. For the defendant to be found guilty of that charge, the government must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly engaged or attempted to engage in a monetary transaction in or affecting interstate commerce. Second, that the monetary transaction involved criminally derived property of a value greater than $10,000. Third, that the defendant knew that the transaction involved proceeds of a criminal offense. And fourth, that the transaction took place in the United States. First element. Monetary transaction. The first element is that the defendant knowingly agreed to engage in a monetary transaction in or affecting interstate commerce. The term monetary transaction means the deposit, withdrawal, transfer, or exchange, in or affecting interstate or foreign commerce, of funds or a monetary instrument by, through, or to a financial institution. The term interstate or foreign commerce means commerce between any combination of states, territories, or possessions of the United States, or between the United States and a foreign country. You must find that the transaction affected interstate commerce in some way, however minimal. The effect on interstate commerce can be established in several ways, including but not limited to that the source of the funds used in the transaction affected interstate commerce, or that the transaction itself involved an interstate transfer of funds. Moreover, you must find that the defendant knowingly engaged, or attempted to engage, in the monetary transaction. I remind you that knowingly means to act voluntarily and deliberately, rather than mistakenly or inadvertently. That is, the act of the defendant must have been the product of his conscious objective rather than the product of force, mistake, accident, mere negligence, or some other innocent reason. B. Second element. Criminally derived property. The second element of this offense is that the monetary transaction involved criminally derived property having a value in excess of $10,000. The term criminally derived property means any property constituting, or derived from, proceeds obtained from a criminal offense. The term proceeds means any property derived from, obtained, or retained, directly or indirectly, through a specified unlawful activity. The statute defines which crimes can be a specified unlawful activity. I instruct you that both wire fraud and securities fraud are specified unlawful activities. Specifically, the indictment alleges that the property at issue was derived from the wire fraud and securities fraud alleged in counts 5 and 6 of the indictment, which concern the GTV private placement. The government is not required to prove that all of the property involved in the transaction was criminally derived property. However, the government must prove that more than $10,000 of the property involved was criminally derived property. C. Third element. Knowledge. The third element of the offense is that the defendant engaged in the transaction, knowing that the transaction involved proceeds of unlawful activity. However, the government is not required to prove that the defendant knew the particular offense from which the criminally derived property was derived. D. Fourth element. In the United States, the fourth element of this offense is that the transaction took place in the United States. 19. Other theories of guilt with respect to all of the substantive counts, that is, counts 5 through 12. The first theory on which the defendant can be guilty of the substantive offenses is by committing them directly. I just provided those instructions to you. There are also two theories on which the defendant can be guilty of the substantive offenses indirectly. 1. By willfully causing another to commit the offense, or 2. By aiding and abetting the commission of the offense. Willful causation first. I will talk about willful causation. Under Title 18 United States Code Section 2, a defendant commits an offense if he possessed the requisite criminal intent and willfully caused someone else to engage in the actions necessary to commit the crimes. Now, what does the term willfully caused mean? It does not mean that the defendant himself needs to have physically committed the crimes or supervised or participated in the actual criminal conduct charged in the indictment. The meaning of the term willfully caused can be found in the answers to the following questions. First, did the defendant have the mental state necessary to commit the substantive offense? And second, did the defendant intentionally cause another person to engage in the commission of the substantive offense? If you are persuaded beyond a reasonable doubt that the answer to both of these questions is yes, then the defendant is guilty of the crime charged just as if he himself had actually committed it. For example, if a defendant intentionally causes someone else to take a step in furtherance of a scheme to defraud, such as by transmitting money, that defendant is guilty if the government proves beyond a reasonable doubt that he acted knowingly, willfully, and with the specific intent to defraud and satisfies the other elements of the substantive fraud count. This is so even if the individual who was caused to make the false statement, or undertake a step in furtherance of the scheme, had no criminal intent. Aiding and abetting. Second, aiding and abetting. It is unlawful for a person to aid, abet, counsel, command, induce, or procure someone else to commit a criminal offense. A person who does that is just as guilty of the offense as someone who actually commits the offense. In order to convict the defendant as an aider and abetter, the government must prove two elements beyond a reasonable doubt. First, the government must prove that a person other than the defendant committed the crime charged. And second, the government must prove that the defendant willfully and knowingly associated himself in some way with the crime, and that he willfully and knowingly engaged in some affirmative conduct or some overt act for the specific purpose of bringing about the crime. The mere presence of the defendant in a place where a crime is being committed, even with knowledge that a crime is being committed, is not enough to make him an aider and abetter. Nor is the defendant's acquiescence in criminal conduct by others, even with guilty knowledge, enough to establish aiding and abetting. An aider and abetter must know that a crime is being committed and act in a way that is intended to bring about the success of the criminal venture. 3. Conspiracy counts 20. Elements of count 1, 2, 3, and 4. Conspiracy. Now that I have explained the indictment's substantive counts, I am going to explain its conspiracy counts. Here there are 4 conspiracy offenses charged. They are, in count 1, a conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, commonly referred to as the RICO Act. In count 2, a conspiracy to commit wire fraud and bank fraud. In count 3, a conspiracy to commit money laundering. And in count 4, a conspiracy to commit securities fraud. Because counts 1 through 4 charge conspiracy offenses, let me explain to you what a conspiracy is. These instructions about conspiracy apply to all 4 counts. A conspiracy is a kind of criminal partnership, a combination or agreement of two or more persons to join together to accomplish some unlawful purpose. The crime of conspiracy to violate a federal law is an independent offense. It is separate and distinct from the violation of any specific federal laws, which I referred to as substantive crimes. If a conspiracy exists, even if it should fail in its purpose, it is still punishable as a crime. Indeed, you may find the defendant guilty of conspiracy to commit an offense even if the substantive crime which was the object of the conspiracy was not actually committed. Congress has deemed it appropriate to make conspiracy, standing alone, a separate crime even if the conspiracy is not successful. In order for the defendant to be guilty of conspiracy, the government must prove beyond a reasonable doubt the following two elements. First, that the charged conspiracy existed, and second, that at some point during the conspiracy's existence, the defendant knowingly and willfully joined the conspiracy. Now let us separately consider the two elements. First element. Existence of a conspiracy. Starting with the first element. What is a conspiracy? A conspiracy is an agreement or an understanding between two or more people to accomplish by concerted action one or more unlawful purposes. For example, the unlawful purpose alleged to be one of the objects of the conspiracy charged in Count 2 is to commit wire fraud, and the unlawful purpose alleged to be the object of the conspiracy charged in Count 3 is to commit money laundering. I will give you instructions on each of these unlawful purposes or objects of the conspiracies later on. The essence of the crime of conspiracy is the unlawful agreement of two or more people to commit a crime. The ultimate success of the conspiracy, or the actual commission of the crime that is the object of the conspiracy, is not required for a conspiracy to have existed. Rather, the government is required to prove beyond a reasonable doubt only that two or more people came to an agreement to accomplish the unlawful object. To prove the existence of a conspiracy, the government is not required to show that two or more people sat around a table and entered into an express or formal agreement, orally or in writing, stating that they had formed a conspiracy to commit a crime. Similarly, you need not find that the alleged co-conspirators stated, in words or writing, what the scheme was, its object or purpose, every precise detail of the scheme, or the means by which its object or purpose was to be accomplished. What the government must prove is that there was a mutual understanding, either spoken or unspoken, between two or more people, to cooperate with each other to accomplish an unlawful act. It is rare that a conspiracy can be proven by direct evidence of an explicit agreement. Rather, in determining whether there has been an unlawful agreement as alleged in the indictment, you may consider the actions and conduct of all the alleged co-conspirators that were meant to carry out the apparent criminal purpose. The old adage, actions speak louder than words, applies here. Often, the only evidence that is available with respect to the existence of a conspiracy is that of disconnected acts and conduct on the part of the individual co-conspirators. When taken all together and considered as a whole, however, these acts and conduct may warrant the inference that a conspiracy existed just as conclusively as more direct proof, such as evidence of an express agreement. Further, although the indictment alleges that the conspiracies began in or around 2018 and continued up to in or around March 2023, it is not essential that the government prove that the conspiracy in question started and ended on those specific dates or that it existed throughout that entire period. Rather, it is sufficient to satisfy the first element if you find that the charged conspiracy was formed, and that it existed for any time within the charged period. B. Second element. Participation. If you conclude that the government has proven beyond a reasonable doubt that a charged conspiracy existed, then you must consider the second element, whether the defendant participated in the conspiracy knowingly and willfully, with knowledge of its unlawful purpose or purposes, and in furtherance of its unlawful object or objects. To act knowingly means to act voluntarily and deliberately rather than mistakenly or inadvertently. To act willfully means to act voluntarily and with a wrongful purpose. An act is done knowingly and willfully if it is done purposefully and deliberately. In other words, the defendant's act must have been the product of the defendant's conscious determination rather than the product of a mistake, accident, mere negligence, or some other innocent reason. It is not necessary for the government to show that the defendant was fully informed as to all the details of the conspiracy in order for you to infer knowledge on his part. Nor does the defendant need to know the full extent of the conspiracy or all of its participants. Indeed, it is not necessary that the defendant knew more than one other member of the conspiracy. It is also not necessary that the defendant received any monetary benefit from participating in the conspiracy. It is enough if he participated in the conspiracy knowingly and willfully, as I define those terms. Although proof of a financial interest in the outcome of the scheme is not essential, if you find that the defendant had such an interest, that is a factor you may properly consider in determining whether he was a member of the conspiracy. Conversely, if you find that the defendant did not have a financial interest in the outcome of the scheme, that is also a factor you may properly consider in determining whether or not the defendant was a member of the conspiracy. If you determine that the defendant became a member of the conspiracy, the duration and extent of the defendant's participation has no bearing on the issue of the defendant's guilt. Some co-conspirators play major roles, while others play minor roles. An equal role is not what the law requires. In fact, even a single act may be sufficient to draw the defendant within the ambit of the conspiracy if it meets the elements I described. The defendant also need not have joined the conspiracy at the outset. The defendant may have joined it at any time at the beginning, in the middle, or at the end, and the defendant will still be held responsible for all that was done before he joined, as well as all that was done during the conspiracy's existence when the defendant was a member. However, I want to caution you that mere association with a member of a conspiracy does not make a person a member of the conspiracy, even when that association is coupled with knowledge that the second person is committing a crime. Mere presence at the scene of a crime, even coupled with knowledge that a crime is taking place, is not sufficient to support a conviction. In other words, knowledge without participation is not sufficient to satisfy the second element. What is necessary is that the defendant participated in the conspiracy with knowledge of its unlawful purpose, and with the intent to aid in the accomplishment of its unlawful object or objects. In sum, if you find that the defendant, with an understanding of the unlawful nature of the charged conspiracy, intentionally engaged, advised, or assisted in the conspiracy for the purpose of furthering the illegal undertaking, you should conclude that the defendant became a knowing and willing participant in the unlawful agreement, that is to say, a conspirator. 21. Liability for acts and declarations of co-conspirators. You will recall that I admitted into evidence against the defendant the acts and statements of others because these acts and statements were committed or made by people who, the government alleges, were co-conspirators of the defendant. The reason for allowing this evidence to be received against the defendant has to do, in part, with the nature of the crime of conspiracy. As I said, a conspiracy is often referred to as a partnership in crime. As in other types of partnerships, when people enter into a conspiracy, each and every member becomes an agent for the other conspirators in carrying out the conspiracy. Therefore, the reasonably foreseeable declarations, statements, and omissions of any member of the conspiracy made in furtherance of the common purpose of the conspiracy are deemed, under the law, to be the acts of all of the members, and all of the members are responsible for such acts, declarations, statements, and omissions. If you find, beyond a reasonable doubt, that the defendant was a member of a conspiracy charged in the indictment, then any acts done or statements made in furtherance of the conspiracy by a person also found by you to have been a member of the same conspiracy may be considered against the defendant. This is so even if such acts were committed or such statements were made in the defendant's absence, and or without his knowledge. 22. Count 2. Conspiracy to commit wire fraud and bank fraud. Because it will be easier to explain, I am going to go through the conspiracy counts out of order and start with count 2, which charges the defendant with conspiracy to commit wire fraud and bank fraud. In order to prove the defendant guilty of count 2, the government must establish the following two elements beyond a reasonable doubt. First, that the conspiracy charged in count 2 of the indictment existed. That is, that there was an agreement or understanding between two or more people to commit wire fraud and bank fraud. And second, that the defendant knowingly and willfully became a member of the conspiracy. You should follow the instructions that I previously provided to you about conspiracies in general, see pages 31 to 35. However, The conspiracy charged in count 2 has a different object or criminal goal than the other conspiracy counts. Remember, the objects of a conspiracy are the illegal goals that the conspirators agree on. The objects of count 2's conspiracy are wire fraud and bank fraud. It is not necessary for the government to prove that the defendant conspired to commit both objects of the conspiracy. You must, however, be unanimous as to the object or objects of the conspiracy, if any. I will now describe these two illegal objects in greater detail. Object 1, wire fraud. I described the elements of wire fraud during my discussion of counts 5, 7, 9, and 11, and you should apply that description here to the wire fraud object of the conspiracy charged in count 2. In other words, to find the defendant guilty of conspiracy to commit wire fraud, you must find that the unlawful purpose of the conspiracy was to commit wire fraud as previously defined. See pages 16 to 21. B. Object 2. Bank fraud. I will now describe the elements of bank fraud. Bank fraud has the following three elements. First, that there was either 1. A scheme to defraud a bank, or 2. A scheme to obtain money owned by or under the custody or control of a bank by means of false or fraudulent pretenses, representations, or promises. Second, that the defendant executed or attempted to execute the scheme with intent either 1. To defraud the bank, or 2. To obtain money or funds owned by or under the custody or control of a bank. And third, that at the time of the execution of the scheme, the bank involved had its deposits federally insured. Now, I will explain each of the three elements of bank fraud in more detail. The first element of bank fraud is that there was either a scheme to defraud a bank or a scheme to obtain money owned by or under the custody or control of a bank, by means of false or fraudulent pretenses, representations, or promises. This element requires proof of the existence of only one of these theories. That is, either that there existed a scheme to defraud a bank, or that there existed a scheme to obtain property under the custody or control of a bank by means of fraudulent pretenses, representations, or promises. You must be unanimous on which theory was proved beyond a reasonable doubt. In order to prove the first theory of bank fraud, that there was a scheme to defraud a bank, the government must prove beyond a reasonable doubt that there was a pattern or course of conduct concerning a material matter designed to deceive a federally insured bank into releasing money or property. I already instructed you on the definition of scheme to defraud, and you should apply those instructions here. See pages 17 to 18. As with wire fraud, which I instructed you on earlier, a fraudulent representation must relate to a material fact or matter. This means that if you find a particular statement of fact to have been false, you must determine whether that statement was one that a reasonable person would have considered important in making his or her decision. The same principle applies to fraudulent half-truths or omissions of material facts. In order to prove the second theory of bank fraud, the government must prove beyond a reasonable doubt that there was a scheme to obtain money or property owned by or under the custody or control of a bank or credit union by means of false and fraudulent pretenses, representations, or promises. It is not necessary that the false or fraudulent pretenses, representations, or promises were made directly to the bank itself. It is sufficient if they were made to any person. So long as the false or fraudulent pretenses, representations, or promises were the mechanism naturally inducing the bank, or custodian of bank property, to part with money in its control. In considering this element of bank fraud, it is unimportant whether a bank actually relied on a misrepresentation. It is sufficient if the misrepresentation is one that is merely capable of influencing the bank's decision. Further, it is not necessary for the government to prove that the financial institutions actually lost money or were deprived of property as a result of the scheme. It also does not matter whether any of the banks involved might have discovered the fraud had the bank probed further. If you find that a scheme existed, it is irrelevant whether you believe that any of the banks involved were careless, gullible, or even negligent. The second element of bank fraud is about the defendant's intent. There are two ways that this element can be met. The first way is if the defendant executed, attempted to execute, or participated in the scheme or artifice knowingly, willfully, and with the intent to defraud a bank or credit union. I've already provided you with the definitions of knowingly and willfully, and you should apply those same definitions here. See pages 19 to 20. To act with a specific intent to defraud requires that the defendant intended, at least in part, to deceive one or more banks or credit unions. The defendant need not intend to cause the banks or credit unions any financial loss. The second way this element can be met is if the defendant executed or attempted to execute the scheme knowingly and willfully, and with the intent to obtain money or funds owned or under the custody or control of the bank. It is not necessary that the defendant intended to defraud a bank. It is also not necessary that the defendant intended to cause harm to the issuing bank or credit union, such as by causing them to lose money, or to anyone else. This element requires that the defendant engaged in or participated in the scheme with an understanding of its fraudulent or deceptive character, and with an intention to help it succeed. It is not required that the defendant participated in or had knowledge of all the operations of the scheme. The third element of bank fraud is that at least one of the financial institutions in question was federally insured at the time of the scheme. This simply means that the financial institution was a bank insured by the Federal Deposit Insurance Corporation, or FDIC, during the time frame alleged in the indictment. The government need not show that the defendant knew the identity of the particular financial institution, or that the defendant knew that the financial institution was federally insured to satisfy this third element. 23. Count 3. Money laundering conspiracy. Count 3 charges the defendant with conspiracy to commit money laundering. In order to prove the defendant guilty of Count 3, the government must establish the following two elements beyond a reasonable doubt. First, that the conspiracy charged in Count 3 of the indictment existed. That is, that there was an agreement or understanding between two or more people to commit money laundering, and second, that the defendant knowingly and willfully became a member of the conspiracy. You should follow the instructions that I previously provided to you about conspiracies in general, see pages 31 to 35. However, the conspiracy charged in Count 3 has a different object than the conspiracy charged in Count 2 or the other conspiracy counts. The object of Count 3's conspiracy is money laundering. The primary federal money laundering statute can be violated in several ways. 3 such violations are alleged to be the objects of the money laundering conspiracy charged in Count 3. 1. Domestic concealment money laundering. 2. International concealment money laundering. And 3. International promotion money laundering. You need not find that the defendant agreed to accomplish all 3 types of money laundering. An agreement to accomplish any one of the objects is sufficient. You must, however, be unanimous as to which type of money laundering, if any, occurred. Each of these money laundering violations has unique elements, which I will now explain. Object 1. Domestic concealment. First, it is a violation of the money laundering statute to engage in domestic concealment, that is, to participate in a domestic financial transaction that involves the proceeds of a specified unlawful activity, knowing that the transaction was designed to conceal or disguise the nature, location, source, ownership, or control of the proceeds of specified unlawful activity. This type of money laundering is known as domestic concealment money laundering. There are 3 elements to domestic concealment money laundering. First, that the defendant conducted or attempted to conduct a financial transaction involving property constituting the proceeds of specified unlawful activity, specifically wire fraud and securities fraud. Second, that the defendant knew that the property involved in the financial transaction was the proceeds of some form of unlawful activity. And third, that the defendant knew that the transaction was designed, in whole or in part, either to conceal or disguise the nature, location, source, ownership, or control of the proceeds of specified unlawful activity. I will now explain each element of domestic concealment money laundering in greater detail. First element: financial transaction involving proceeds of specified unlawful activity. The first element of domestic concealment money laundering is that the defendant conducted a financial transaction involving property constituting the proceeds of specified unlawful activity, specifically wire fraud and securities fraud. The term conducts includes initiating, concluding, or participating in initiating or concluding a transaction. The term financial transaction means 1. A transaction involving a financial institution that is engaged in, or the activities of which affect, interstate or foreign commerce in any way or degree, or 2. A transaction that in any way or degree affects interstate or foreign commerce, and involves the movement of funds by wire or other means, or involves one or more monetary instruments. I instruct you that a federally insured bank constitutes a financial institution. A transaction involving a financial institution includes a deposit, withdrawal, transfer between accounts, exchange of currency, loan, extension of credit, purchase or sale of any stock, bond, certificate of deposit, or other monetary instrument, use of a safe deposit box, or any other payment, transfer, or delivery by, through, or to a financial institution by whatever means. The term interstate or foreign commerce means commerce between any combination of states, territories, or possessions of the United States, or between the United States and a foreign country. In determining whether someone is engaged in, or whether his activities affect interstate or foreign commerce, the involvement in interstate or foreign commerce can be minimal. Any involvement at all will satisfy this element. The term monetary instrument includes, among other things, coin or currency of the United States or any other country, personal checks, traveler's checks, cashier's checks, bank checks, money orders, and investment securities or negotiable instruments in bearer form or otherwise in such form that title thereto passes upon delivery. The term proceeds means any property derived, directly or indirectly, from some form of unlawful activity, including the gross receipts of such activity. Proceeds can be any kind of property, not just money. I already described the meaning of specified unlawful activity. In this case, the government has alleged that the funds in question were the proceeds of wire fraud and securities fraud, that is, the conduct alleged in counts 5 through 11 that I already described to you. I instruct you that, as a matter of law, wire fraud and securities fraud fall within the definition of specified unlawful activity. However, it is for you to determine whether the funds here were in fact the proceeds of wire fraud and securities fraud. The government does not need to prove both of these specified unlawful activities. It is sufficient if you find that the government has proven beyond a reasonable doubt that the financial transaction involved the proceeds of wire fraud or the proceeds of securities fraud. But you must agree unanimously as to which of these specified unlawful activities the government has proven, and you must agree unanimously that a financial transaction involved the proceeds of that specified unlawful activity. 2. Second element. Knowledge. The second element of domestic concealment money laundering is that the defendant knew that the property involved in the financial transaction was the proceeds of some form of unlawful activity, specifically activity that constitutes a felony under state, federal, or foreign law. Thus, to satisfy this element, the government does not have to prove that the defendant specifically knew that the property involved in the transaction represented the proceeds of wire fraud, securities fraud, or any other specific offense. The government only has to prove that the defendant knew it represented the proceeds of some illegal activity that was a felony. I instruct you that, as a matter of law, wire fraud and securities fraud are felonies under federal law. 3. Third element. Designed to conceal or disguise. The third element of domestic concealment money laundering concerns the purpose of the transaction. Specifically, the government must prove beyond a reasonable doubt that the defendant acted with knowledge that the transaction was designed to conceal or disguise the proceeds' nature, location, source, ownership, or control. Thus, if the defendant knew that a transaction was designed, at least in part, either to conceal or disguise the true nature, location, source, ownership, or control of the property in question, this element is satisfied. However, if the defendant knew of the transaction, but did not know that it was designed, at least in part, either to conceal or disguise, this element has not been satisfied. B. Object 2. International concealment. Second, it is a violation of the money laundering statute to engage in international concealment, that is, to participate in a foreign financial transaction that involves the proceeds of a specified unlawful activity, knowing that the transaction was designed to conceal or disguise the nature, location, source, ownership, or control of the proceeds of specified unlawful activity. There are 3 elements to international concealment money laundering. First, that the defendant knowingly transported, transmitted, or transferred a monetary instrument or funds from a place in the United States to or through a place outside the United States, or to a place in the United States from or through a place outside the United States. Second, that the defendant did so with knowledge that the monetary instrument or funds involved represent the proceeds of some form of unlawful activity. And third, that the defendant knew that the transportation, transmission, or transfer was designed, in whole or in part, to conceal or disguise the nature, location, source, ownership, or control of the proceeds of specified unlawful activity. The second and third elements are the same as the second and third elements for domestic concealment money laundering, and you should follow the instructions I previously provided as to those elements. See pages 44 to 45. I will now describe the first element in greater detail. The first element that the government must prove beyond a reasonable doubt is that the defendant transported, transmitted or transferred or attempted to transport, transmit, or transfer a monetary instrument or funds 1. From a place in the United States to or through a place outside the United States, or 2. To a place in the United States from or through a place outside the United States. I previously defined the term monetary instrument, and you should use the same definition here. See page 43. The term funds refers to money or negotiable paper that can be converted into currency. Transport, transmit, and transfer are not words that require a definition. You should give them their ordinary, everyday meaning. The government need not prove that the defendant physically carried funds or monetary instruments in order to prove that he is responsible for transferring, transporting, or transmitting. All that is required is proof that the defendant caused the funds or monetary instrument to be transported, transferred, or transmitted by another person or entity. See Object 3 International Promotion. Third, it is a violation of the money laundering statute to engage in international promotion, that is, to participate in a foreign financial transaction with the intent to promote the carrying on of specified unlawful activity. There are 3 elements to international promotion money laundering. First, that the defendant conducted or attempted to conduct a financial transaction involving property constituting the proceeds of specified unlawful activity, specifically wire fraud and securities fraud. Second, that the defendant knew that the property involved in the financial transaction was the proceeds of some form of unlawful activity. And third, that the defendant acted with the intent to promote the carrying on of specified unlawful activity. I already described the first and second elements to you in connection with domestic concealment money laundering, and you should apply those same instructions here. See pages 42 to 44. The third element that the government must prove beyond a reasonable doubt is that the defendant acted with intent to promote the carrying on of specified unlawful activity, specifically wire fraud and securities fraud. To act intentionally means to act willfully, not by mistake or accident, with the deliberate purpose of promoting, facilitating, or assisting the carrying on of wire fraud and securities fraud. If you find that the defendant acted with the intention or deliberate purpose of promoting, facilitating, or assisting in the carrying on of wire fraud and securities fraud, then the third element is satisfied. 24. Elements of Count 4. Securities fraud conspiracy. Count 4 charges the defendant with conspiracy to commit securities fraud. The indictment alleges that the defendant conspired to commit securities fraud by agreeing to fraudulently induce investors to participate in the GTV private placement, the Farm Loan Program, and G-Clubs by providing materially false and misleading information and representations in connection with purported shares of GTV common stock and purported companies affiliated with GTV. In order to prove the defendant guilty of Count 4, the government must establish the following 3 elements beyond a reasonable doubt. First, that the conspiracy charged in Count 4 of the indictment existed. That is, that there was an agreement or understanding between 2 or more people to commit the crime of securities fraud. Second, that the defendant knowingly and willfully became a member of the conspiracy. And third, that one of the members of the conspiracy, it does not have to be the defendant, knowingly committed at least one overt act for the purpose of furthering some object of the conspiracy. First and second elements. Existence of conspiracy and participation. The first 2 elements, that the conspiracy existed and that the defendant knowingly joined it, are the same as the first 2 elements for the wire fraud and bank fraud conspiracy alleged in Count 2 and the money laundering conspiracy alleged in Count 3. See pages 31 to 35. Accordingly, you should follow the instructions I previously provided to you about conspiracies in general. The conspiracy charged in Count 4 has a different object or criminal goal from the conspiracies charged in Count 2 or 3. The object of Count 4's conspiracy is to commit securities fraud. I already described the elements of securities fraud, and you should use that description here. In other words, to find the defendant guilty of conspiracy to commit securities fraud, you must find that the unlawful purpose of the conspiracy was to commit securities fraud as I previously explained. See pages 22 to 27. I will explain the third element requiring an overt act next. B. Third element. Overt act. The third element that the government must prove beyond a reasonable doubt is that at least one overt act was committed in furtherance of the conspiracy by at least one of the co-conspirators, not necessarily the defendant. An overt act is any act that is done to further an object of the conspiracy. An overt act may be a criminal act or the crime that is the object of the conspiracy, but it need not be. It may even be a seemingly innocent act so long as it is a step in carrying out the conspiratorial scheme. In simple language, the overt act element is a requirement that the agreement went beyond the mere discussion stage. The overt act requirement means that you must find that one of the co-conspirators took some action during the life of the conspiracy to further the conspiracy. In order for the government to satisfy the overt act requirement, it is not necessary for the government to prove the overt acts alleged in the indictment. That is, you might find that overt acts were committed that were not alleged at all in the indictment. It is sufficient for the government to show that the defendant, or one of his alleged co-conspirators, knowingly committed any overt act in furtherance of the conspiracy during the life of the conspiracy. You need not reach unanimous agreement on which particular overt act was committed in furtherance of the conspiracy. You just need to all agree that at least one overt act was so committed. The court said, "It's 5:01, so we're going to stop our instructions here. Now that you know that the parties have rested, it's very tempting to start discussing the case, either with someone at home or even when you're back in the jury room or in the elevator, but it's absolutely prohibited. You cannot discuss the case until I tell you, now is the time to deliberate. I have to finish my instructions on the law. The lawyers must give their summations, so the same old rules apply. These instructions that were handed out to you earlier are going to be collected. We'll have them for you in the morning. You're not allowed to discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch, or listen to anything from any source about anything that has to do with this case. Have a good evening."
The law clerk said, "Jury exiting."
Jury not present. Continued on next page.
The court said, "Please be seated." All right. So I need tomorrow morning to finish pages 50 to 68 of the charge, and then we will start with the summation of the prosecution. Who will be summing up?
Ms. Murray said, "AUSA Finkel, Your Honor."
The court said, "And for the defense?"
Ms. Shrofa said, "Your Honor, Mr. Kumraju is going to give the defense summation." Your Honor, I was wondering if we could possibly make the defense would ask the court to consider. Since the tail end of the jury instructions are not specific to the law, would the court consider allowing the summations to begin first thing in the morning and then give the instruction at the end so that all three summations are done in one day? I hadn't had a chance to confer with the government. The last part of the jury instruction are also sort of the non-statute related ones, the general instructions. And then the marshal is given the oath. And I just thought that it might flow in a sense better and allow everybody to start in the morning and sum up.
The court said, "So my understanding is that I would finish the substantive charges and then there would be the summations, and then I would give the more general instructions that are in section 6 of the charge. You're saying that you want me to do it in a different order?"
Ms. Shrofa said, "I was just suggesting that all three summations could be finished. We could start with the summation and finish all of it, and all the remaining instruction could be at the end. It's just a suggestion. But if the court prefers not to, that's fine too. I was just trying to get all three summation in the morning."
The court said, "I'll hear from the government."
Ms. Murray said, "We defer to the court. We do think it makes sense to complete the law portion that Your Honor has started. There are very little pages left, then move to summation. And then, as Your Honor said, move to section 6 of the instructions."
The court said, "I think that because I've told them that I was going to do it one way, if I leave out substantive charges that it could be confusing when the lawyers start to talk about charges that I have not gone over. So I'm going to finish up pages 50 to 68 to the charge tomorrow morning, and you can go right into summations.
Ms. Shrofa said, "Okay, Your Honor."
The court said, but also consider that one of the jurors had said that he needs a break at 11:30. So no matter what, we'll break at 11:30, and we're going to have to break again at 2:30. It could be a 10-minute break at 11:30. I understand what he needs is a bathroom break. At some point we need to break at lunch. You might want to discuss what you consider to be the optimal break time for lunch.
Ms. Murray said, "Your Honor, we're happy to do that. And we can follow up by email with the court with ideally a proposed joint suggestion."
The court said, okay, thank you. Have a good evening.
Adjourned to July 10, 2024 at 9 a.m.